Yes, you know, when the Civil War was over with, you know, the black rich, like Robert Johnson and that black woman in Louisiana that had all those slaves. Yeah, she had over about, I forget how many slaves she had, about 400 or 500. I'm telling y'all, man, they've lied to us about everything, my brother. And I'm not mad at the black man for this. You know who I know? I'm blaming this on the devil and evil people.
Pay attention.
All 13 colonies.
Interesting. Anybody know that? There's a movie. Well, no, it's like a docudrama. What's the brother with the deep voice that the actor, he played in it? It's called Feast for All Saints. It's supposed to be the history of Louisiana. It goes all the way back to the Haitian War and all that stuff, and comes over here to Louisiana, but they have a whole different outlook on it. But this guy has a whole different outlook on it. But just keep that in mind. We're going to address that soon.
Peoples are involved in capturing and selling and bartering Native captives. There are more Native Americans exported from North America to the West Indian colonies than there are African slaves imported to the North American colonies. So many of the sources that we have to work with, and I think this is where so many of the myths that inform the legacies that people are still struggling with today, many of the primary sources that we have to work with are sources that were written by white missionaries, white federal governmental officials, and white citizens from the Deep South. And often those sources that describe Native slaveholding practices in particular, Native economic practices in general, and slaveholding in particular, tell us as much about if not more, about the author of those sources than they do about the actual subject. But Native peoples are involved in capturing and selling and bartering Native captives.
Okay, so this lady right here is making a presentation in front of people at a podium, looking at notes. So we just saw the previous one, and he was talking about all 13 colonies. Then we have this one about slavery, what they would consider to be slavery. But I got a different take on it. I don't think it is what we consider to be slavery or what we've seen on TV in the movies. That's dramatic. That's extreme. But I think they play it out in the movies based on their experience, but they want to flip it around in their movies, in their fantasies, to be the one that actually is the slave owner, which they were not.
More Native Americans exported from North America to the West Indian colonies than there are African slaves imported to the North American colonies. So many of the sources that we have to work with, and I think this is where so many of the myths that inform the legacies that people are still struggling with today, many of the primary sources that we have to work with are sources that were written by white missionaries, white federal governmental officials, and white citizens from the Deep South. And often those sources that describe Native slaveholding practices in particular, Native economic practices in general, and slaveholding in particular, tell us as much about, if not more, about the author of those sources than they do about the actual subject. But Native peoples are involved.
All right. We're gonna address that, but that's a whole nother topic. That's a whole nother topic, and I want to make sure that we stay on topic. I really want to hammer down the status issue, because I think at the end of the day, we've came to the bookmark and the point on everything. What is causing the confusion? Status. In every sense of the word. Okay? So we're going to address all this.
Going on taxability?
Yes.
All properties are taxable.
I think they're not. I'm going to present my case how they're not. Okay.
There are some properties that are tax exempt, but for a residential improvement in a residential home, it is taxable.
According to somebody, it might be taxable, but I'd like to present my case.
Okay.
The property tax is unlawful and unconstitutional. First of all, it infringes on the people's right to own property. The governments of Hall County and Hall County Superior Court are not governments at all. They are privately held, foreign-owned, for-profit corporations. The following have been corrupt and complicit in committing crimes against the people on behalf of these corporations: judges, attorneys, district attorneys, doctors, politicians, governors, senators, mayors, city councilors, county commissioners, sheriffs, bankers, court clerks, and county clerks who have participated in the deception, exploitation, and destruction of the people that you were supposed to serve. The tide has turned, and the remaining time for this corruption is very short. The U.S. corporation is dead. The republic is restored. President.
Thought that was interesting. Yeah. That's what they talking about. In the meantime, what we talking about? All right. Let's start with this one. Now we're going to get back into the situation with the young man and the so-called Asian cat that took out that young man over a bottle of water that cost $1 that he actually put back on the shelf. But let's watch carefully.
Racially profiled. They followed him around. He was shopping. He took 4 waters, he put them back. He even showed them by shaking his hoodie that he took nothing. And he walked out of the store. He didn't argue with them. He didn't have any confrontation. He didn't curse them. He just walked out. He was respectful. And yet 2 grown people chased him. He fell and they shot him. He shot him dead, like as if he was a dog. And I do not understand how that jury can come back and say that he was not guilty. He was in a runner's stance. It was shown by the pathologist, and they said he was not guilty. It was devastating for me to get a call from Alvin S. Glenn letting me know that Rick Chow was released. That broke me more than you can ever imagine, because my murderer of my son was set free. And it's not fair and it's unjust. And nobody can tell me that this is not racially motivated, because I'm not supposed to be on social media anyway. But when I go and I look at my social media, I have racist people coming to my page, going under my son's pictures, leaving the most horrific things, saying that they're glad he's dead, good riddance, and I am tired. I don't want this to happen to any other child. No black or brown child. You have to go through this. No parent should have to go through this. This has to stop today. And I just learned today that South Carolina, if it's a murder charge, that they cannot bring in any of your prior acts. Rick Chow shot 2 people before. Rick Chow accosted a child in that store and beat her up with a gun on her hip. And none of that information could be brought to light. And I do not think that is fair. And if that is on the law books, that needs to be changed.
Whoa, that's why you can't bring up prior acts. That's what you would call double jeopardy type thing. You can't be tried twice for the same thing. But it seemed like that's not what she's talking about. Sheesh.
Because if that was not there, then my son would have gotten justice. And to allow this person to terrorize this neighborhood for 12, 13 years is ridiculous. And it's just showing that it's okay to treat black and brown people wrong, and it's not. My son loved everybody. He would tell me like, oh, Mom, you're being judgmental. You shouldn't do that. That's against God. And the devil shot him dead, and he laid right there. And we got no justice from South Carolina. And I think it is disgusting. And I don't even know why. I have no words. But every day I will not be able to speak to my son, hear his voice change, see him grow, go to prom. He will never get married. I would never hold my grandchildren, nothing. But Chow is able to go home with his lion son, Andy Chow, and they're able to have dinner with the wife, Alice, who all three of them came out that store and they chased my baby. And I think the entire family should be held accountable because it was racially profiled. And I do not think that it is right, and they all should be punished. And I don't know what laws that we need to create to help our people, but it needs to be done, and it needs to be done now. Cyrus should not be gone. None of our children should be gone from the acts of racism, from profiling, from any of that. He should be here. And until the world treats us like we are human beings, I mean, come on. Y'all hire us. Y'all want us around. You like our culture. You want to listen to the music. You want to wear our clothes. You want to do all of that stuff. But when it comes to protecting us and when it comes to looking at our children, you look at us as if we are animals, and we are not. I am a college educated woman. I hold a master's degree in information technology management. My son was not a thug. He was a 14-year-old boy who was trying to find his way. And for any person that acts like when they were 14, 15, 16, 17, that they did not do nothing wrong, that they did not smoke and drink and have sex and do whatever that they were not supposed to do by their parents, it is a lie. And it is judgmental, and I refuse to allow any of you to sit up there and make it seem like we were bad parents, because we were not. All of our children make mistakes, but I don't see anybody saying, oh, well, you know what? My kid did X, Y, and Z. My kid did X, Y, and Z. No, they're coming onto my page and try to demonize my child, and I will not have it. And it stops today. Keep your opinions to yourself. And until you are in my shoes and you have to bury a child, I don't want to hear nothing from you.
Well said. This goes a little bit beyond status. This goes beyond what did Ice Cube say? Here's what they think about you. Here's what they think about you. And you look around and you really can't find anything on it on these mainstream news channels. Instead, they're actually going back now, want to talk about Carmelo Anthony and what he did to the white boy. This is what they want to talk about. They want to bring that back now. Oh, yeah. Oh, what is that? An eye for an eye? But wait a minute. Y'all white people. This dude's an Asian child. He's a foreigner. So you're siding with the foreigner. Okay, very good. How about that? Better yet, let's do this. Let me go find that. Should have been thinking in advance. Let's go find a Fox News. Let's deal with Fox News. Let's deal with a Fox News. Where are we at here? There we go. Fox News today. Let's see if we can find something. Let's see. Can we get some Fox News today on Carmelo Anthony. All right. Let's go here. Let's see what they say. They saying about this young man. Let's see what they got to say about that. All right, let's bring him up. Let's see what they got to say.
In the closely watched murder trial of Carmelo Anthony. He is the Texas teen accused of fatally stabbing another student at a high school track meet last year. Brooke Taylor is following this story for us. She is live in Dallas. Good morning, Brooke.
Hi, Jackie. This has become a high-profile case. More than 100 people showed up to court today, but many of them were turned away because there's limited seating here. So defense attorneys for Carmelo Anthony, they are expected to argue self-defense, while prosecutors say that he provoked this attack and he brought a knife to a high school track meet. So it all started when prosecutors say that 17-year-old Austin Metcalf asked Carmelo Anthony to leave a team tent during a high school track meet back in April of 2025. They say the confrontation quickly escalated, ending when Anthony pulled out a knife and stabbed Metcalf in the chest, killing him. Now, Anthony has pleaded not guilty to murder. Race has become a major issue surrounding this case. It was even front and center during jury selection. Several jurors, they were dismissed after raising concerns about whether they were able to be impartial. Supporters, meanwhile, they have raised hundreds of thousands of dollars online to help for Anthony's legal defense.
The state of Texas requires that says that you have a right to defend yourself, then we should be able to defend ourselves no matter what the race is, what background you come from.
Well, prosecutors, though, say Metcalf was unarmed when he was stabbed. His twin brother, who was with him during this confrontation, previously spoke to Fox, describing the moment before his brother died in his arms.
I whip my head around, and then all of a sudden I see him run down the bleachers, grabbing his chest. I push my hand on there, try to make it stop, and I grabbed his head and I looked in his eyes.
Look at the guy. Look at Will Kane. He over there shaking his head. Oh, man. Oh, man. And look at Mama over there crying. Uh-huh. You talking about this Fox News. It's major play right here. Major play. This is major play right here. That's enough.
I just saw his soul leave, and it took my soul too.
Look at that. All that fake shit. Let's go back here. Let's go to child and shooting in South Carolina. See what they talking about here. Let's see here. Newsweek, News 19, ABC News. South Carolina jury found store owner not guilty. All right, let's see what this is.
Carolina County of Richland versus Chike Rick Chow. We, the jury, unanimously find the defendant, Chi Rick Chow, as to the charge of murder, not guilty.
A jury found a store owner to be not guilty of murder after he shot and killed a 14-year-old boy. The shooting happened back in 2023 in Columbia, South Carolina. Rick Chow was accused of killing 14-year-old Cyrus Carmack Belton outside of a Shell gas station. Prosecutors said that Chow and his son chased the 14-year-old boy after they believed he stole water bottles. Chow fatally shot Carmack Belton in the back after his son claimed that the teen had a gun. Chow claimed he acted in self-defense.
How about that? You acted in self-defense and you shot him in the back. Okay.
Okay, for those of you that may not have.
Okay. We don't need all that. Let's keep going. 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 No Fox News. No Fox News, no CNN, no MSNBC, non-existent, no national coverage.
I remember growing up and watching shows with my father. And I'm old enough to date myself a little bit that we would actually listen to radio shows. And one of the radio shows that we would listen to quite often is a guy named Paul Hurley. And what he would do is he would tell stories. And then telling stories.
You watched radio, you listen to radio shows. Dude, you are not.
Stories, what he would do is tell a story that he thought that everybody actually knew. He would tell a story and he would give details of a story that he thought that everybody actually knew already. And he would tell it, and he would tell it in his interesting way, but what he would do is intentionally leave out parts of the story so that people would be a little confused because they.
So why do you think they left out part? Why do you think the state of South Carolina / that county left those things out? When you think that they was playing point guard and you was over there sitting on the side waiting for everything to shift over to them so they could throw you a lob? Focus on us. Now let me draw the defense and we're going to throw you that lob. We want everybody to be focused on us because everybody is confident that the state of South Carolina, the DA's office, oh, they gonna win. That county, they gonna win. DA, they win. If they bring you in there, they win. Unless they decide that this is one we can lose in the interest of what they call justice. So how about we come over there and then we sit and drag them people over to us, but oops, we left something out. Oops. We forgot to add this. Oops. We didn't provide any other necessary evidence, discovery. Here you go. And you take that thing and you grab that thing like Shaq. Well, Shaq retired. Anybody. Can't think of anybody I want to name. But you grab that ball and you pick it up and you slam dunk that. That's what South Carolina did. They threw you a lob, buddy. If you really think and you going to convince anybody that you actually won that case fair and square, use a damn lie because you knew he was guilty by all outdoors. Something was missing here. Something had to be missing. What is missing? He was shot in the back. What else is missing? He was by himself. What else is missing? It was $1 bottled water. What else is missing? He put it back. What else is missing? It was 3 against 1. What else is missing? They have a history of doing this. What else is missing? They ran after him. He left out. They ran after him. He was running from them. What else is missing? Right. Status is what's missing. Here's what they think about you is missing. Here's what you did. You went along with, I'm all right with that. I just want to get some notoriety. That's what I want to do. That's what's missing. You know what else is missing in this drop? What else is missing is no ABC, no NBC, no CBS, no Fox News, nowhere. Local. But we did see what is considered to be on the main screen of what you would consider of the mainstream media. And then we have it right here. So I guess this is the guy. This is the guy. This is the youngster. So the other thing we was talking about, me and one of the brothers, we was talking about the fact that how is this old man chasing this young man down and be able to square up, plant his feet, and shoot him dead in the back, and be able to knock him down and kill him? How is that possible? Couldn't have done it. Not him. That's the guy right here. This guy right here. That's who shot him. And the old man took the charge. Because if he would have been in front, he would have been the one that would have been able to go down for that. They knew they didn't have nothing on him because he ain't the one that shot. They know that. But they just played it right in front of your face, and they made sure they put a brother right in front. Pretty much killed his career. Nobody's going to mess with him. If what he did, nobody's going to mess with him. He's going to have to want to be hired in one of them agencies or whatever in order to, have a job. Because if anybody hires him in South Carolina, beep. Let's see what this guy said. Okay, I just flashed. Let's see what he said.
The weekend off for some medical interventions, among them my finger. I decided I would do a video and catch everybody up on what's been happening in the Rick Chow case, and then launch into a discussion of Andy Chow's testimony. So stick with me. I'll be right back.
I won't do all that. We'll come back to that. All right. So we pretty much got a clear idea of what's going on. That is not on the screen. Nobody knows about it. But see, the one issue is that with all of the mainstream media, they still hold power in the information. Once it hits the national syndicate and it's being shown, at the end of the day, you're gonna get a little bit more play. Let me just say it that way. I mean, but at the end of the day, what this sister said right here is, where is she at? Was pretty much right on point. It's pretty much right on point. And at the end, when is this going to stop? And now it's more like, okay, this is what it is. You don't have to tell me twice. When is it going to be? You don't have to tell me twice. Not when is this going to end, but when. You don't have to tell me twice. I got it. Get it. Good. This is what we're doing here. Okay. We're going to make sure that doesn't happen again. Now, if that guy still has that gas station, that store, Tomorrow, hey man, you get what you get. If he still stays there, I wouldn't give a damn. Somebody is going to have to take that penitentiary chance. See, but this is the organization of everything. They want us to be docile, while they are not docile. Let me go back and show you something real quick. Let me go back and show you a couple things. This is what they doing. Let me go back here. This is what they doing.
All right, I'm going to give you my presentation. And
Also, you're going on taxability.
yes,
All properties are taxable.
they're not. I'm going to present my case how they're not. Okay.
There are some properties that are tax exempt, but for a residential improvement in a residential home, it is taxable.
According to somebody, it might be taxable, but I'd like to present my case.
Yes, ma'am.
The property tax is unlawful and unconstitutional. First of all, it infringes on the people's right to own property. The governments of Hall County and Hall County Superior Court are not governments at all. They are privately held, foreign-owned, for-profit.
Letting it be known. Letting it be known.
This is going to blow y'all away. I'm telling you, this is going to rock the world. Okay? All 13 colonies had rich black people in those colonies, rich black people, families, wealthy black families in all 13 colonies, and they all owned slaves.
Without a doubt. Without a doubt. But at some point in time, we're going to have to make a decision. Either we're going to get in the game, stand your ground, or stop talking. This is what's got to really happen. If you're not going to do nothing, you need to stop talking. If you're not doing anything, if you have not pushed your line in regards to what is actually taking place, and you did it on your own without utilizing those resources, you need to stop talking. Because outside of that, if you're not doing that, if this is what you're doing, you're a coward. And you're a traitor. You're a sellout. You're a provocateur. You're nothing. Yeah, you go home and stack your little money and stuff it up your ass. That's what you can do with it. And everybody else that follow people like that can do the same, because you're nothing but a slave. Yeah, I said it. You're a slave. If you can't stand on your own two, if you can't spit it, if you're not willing to go down with the ship, and you're not willing to call out people that are actually working against the grain, let me just say that, working against the grain, but showing as if they are with the grain, then you know what I'm saying? You're going to get what you get. They just got introduced to the fact that they thought I guarantee you they thought that was a slam dunk. The district attorney's office came to them. Yeah, the sheriff came to them. The police investigators, everybody came to them and was like, yeah, we're going to make sure you get justice. And they didn't. What they're going to get is some civil relief. They're going to get some money. But I guarantee you, them guys are going to be out and about, hanging out, chilling. Absolutely. And I guarantee you that them people don't even live nowhere within a 30 square mile radius of that community. Guaranteed. Now, let's keep going.
here, he grabbed the 4 water bottles and puts all 4 back. And she's standing there doing what? Leaving peacefully. Look, they're so scared of him.
I wanted to piece together all of the surveillance footage that was shown because number one, it shows all of the angles. Number two, I'm tired of the stupid comments of people. Oh, but he stole the water bottles. Oh, but he threatened them. No, he didn't. No, he didn't. In fact, his own surveillance footage shows that he blatantly lied to police, that he never stole anything, that from the moment he walked in, he was respectful. He put the backpack down. He didn't argue with anyone. And that she, on the other hand, his wife, harassed him the entire time. When he was walking towards the water bottles, she's standing over the chips like this, monitoring him like he's a criminal. They then accuse him, even though the surveillance footage, it's 1, 2, 3, 4 water bottles being put back. She still followed him, still questioning him. The son now jumps in. And instead of him arguing with them, he said, I don't have anything here. He shakes his hoodie and he walks out the door. They followed him, all 3, not just him and his son. And what breaks my heart, on top of the fact that he is not here to even speak on his behalf, the fact that he was shot while he was trying to get up from the floor after tripping, is the fact that no child should ever have to walk into a store and be taunted in this manner, followed throughout the store at 14 years of age. I just asked myself, what does that do to a person? How does that jack them up in their mind, in their soul, to think that you can't even walk into a store innocently? All of them deserve to be in jail. In the next video, I'll go into day 3.
All right. Let's go ahead and decompress on that. Okay. No problem. All right. What's going on, big dog? Big dog, big dog. What's going on? Peace to you, brother. King Chameleon, what's going on, brother? Yes, sir. All right. So here's what we're going to do real quick. Let's just take a quick 1-minute timeout. Because we got to shift this. I mean, it's hard, but we got to. We got to move on from this. We got to move on from this. Got to move on from this. All right. So we're going to take a quick break. We'll be right back. Ah, boy. We'll keep that music down a little bit in the background. Let me know if that's a problem for you guys. All right, so look, we're going to go to this young lady, right? We're going to go to this young lady, and we're going to get back into the status situation. You know, we had to discuss that. We are going to discuss it a little later. I want to do a specific build on that. So we're not just working off emotions and feelings, that we put something together, put it on the tube, and hopefully they might see it. Because it's not over. In that jurisdiction, what was the claim? Who brought the claim? What was everything going on? But I don't want to get into that. We're going to come back to that. And hopefully, if anybody listens, we will be able to get this out to her and the family, and they can make sense of it. Because obviously, the state of Carolina was what they call that, either incompetent, negligent, or what you call in regards to attorneys, because district attorneys, prosecution, they're still bound by attorney ethics. So if they actually were if the attorneys were negligent in their acts in regards to representation, because they were supposed to be representing that young man and the and the mother and the father of that young man. They were supposed to be representing them as the real party in interest, the injured party. Now, if they didn't do that, then now we got an issue here. But I just want to just kind of let that sink in for a minute. I can't even think of the term right now when an attorney acts in a certain fashion where an attorney is shoot, can't think of it. Anyway, man. All right, let's move forward. Let's move forward.
So if the borrower is always defined as the grantor, we ask ourselves, then what the hell does grantor mean? Grantor, it just means that you have the ability to grant something. We're going to keep it stupid simple. We're not going to overcomplicate this. If I'm a grantor, that means I have the ability to grant something. What am I granting? You start having to ask these questions, guys. You got to ask questions. All right, the continuation. If you are the grantor, it means that you are the one that funded the contract. This is your standing. Y'all.
All right, get past all that. But look, what she said is, if you are the grantor, that means that you are, wait, what did she say? That you are the hold on, damn, I can't even rewind that. That you are the you are the borrower that funded this contract. If you are the grantor. All right, so keep in mind, grantor. Let's play it again.
Gotta follow me because I want to teach you. I don't want to just help you extinguish your mortgages, guys. I really like people who want to learn the process, so don't mind me. All right, this is how I teach. But if you are a grantor, that means you're granting something. That means, guess what? You are the one that funded this contract. And for those of you that get a little ahead, yes, this contract is a trust, and you should know where I'm going with this. So you're going to scroll all the way down in your deed of trust, and you're going to see this beautiful, beautiful section called transfer of rights in the property. When you get to this section, y'all, all right, it's going to read, the security instrument secures to lender the repayment of the loan and all renewals and modifications of the note. I'm going to say that again. The security instrument, meaning this deed of trust, this security deed, this deed of trust, whatever the hell they want to call it, right? Secures to the lender the repayment of the loan. Stop right there. So you telling me the actual instrument itself pays for itself. That's exactly what this just told you. Y'all overcomplicated because you weren't taught how these things work. You weren't taught how to actually perform, okay? We don't pay for things around here. We perform our duties. Stay with me. You got to start learning what these words really mean, okay? So that means the security instrument basically pays for itself, y'all. That's exactly what this means. All renewals and modifications of no, it don't matter what they do, flip flop, whatever they want to do with it. It pays for itself. Fact check me. Y'all know how I roll. All right, the continuation. You're going to then go to a section and you're going to see this thing called RESPA. One of my favorite parts. RESPA. If there is a surplus of funds held in an escrow as defined under RESPA, the lender shall. Did it say the lender might? Huh? It said shall. All right, shall. The lender shall account to borrower for the excess funds in accordance with RESPA. So that means if there's extra money laying around that they made on you, which we know they did because I taught you guys already on my previous videos that they hypothecate your loans. We're not there yet. I'm trying to help y'all just learn the vocabulary, all right? So that tells me if there's money left over. Okay, so if the borrower is always defined as the grantor, we ask ourselves, then what the hell does grantor mean? Grantor, it just means that you have the ability to grant something. We're going to keep.
All right. It's running it back again. So it's running it back again. So the understanding of these terms and what they actually mean is the only way that you'll be able to express it, spin it, and make it make sense in order to get any type of restoration, reparations. I mean, because all of that is something that is conclusive in everything that we do every day. Depending on what your status is, depending on the venue. But the one thing that doesn't change is the fact that who does the granting, who is the grantor, trustor, donor, settlor, creator, bailor, mortgagor, obligor. They twist these words up and do not clearly define them for you. Once they don't define them for you, there's no meeting of the mind. And then if they try to do something that is considered to be detrimental to your well-being, whatever it might be, that is constructive. Or what they also say in what you would consider to be criminal nature, it will be what do they call that? Conspiracy before the fact. Man, I don't know why I'm drawing a blank. Man, I can't think of these words right now. Sheesh. But anyway, under the circumstances, nevertheless. But all these things are what you will consider be something that had willful intent. That's not the word I'm looking for, but we'll just use willful intent. Misrepresentation of material evidence. Those things are very important in those dealings, and it covers everything. Even in the situation where you're dealing with that young man. But I don't want to take it to that situation because a lot of people think crime is crime and that's how it is based on how they see it or how they experienced it or how they witnessed somebody else experiencing it. You know what I mean? So, but I want to bring it here back to mortgages. In this situation, every situation is that. So let's run it back again.
It's stupid simple. We're not going to overcomplicate this. If I'm a grantor, that means I have the ability to grant something. What am I granting? You start having to ask these questions, guys. You got to ask questions. All right, the continuation. If you are the grantor, it means that you are the one that funded the contract. This is yours.
All right. So this is her take on it. If you are the grantor, you are the one that funded the contract. Now, that's pretty much what I have been saying. I haven't used the word grantor yet. But what I have used is what she's going to pretty much talk about, just following up. When we're dealing with deeds of trust, right? When we get into the deed of trust and it says we transfer all rights and title over, so on and so forth, let's see what she says about this.
Y'all gotta follow me because I want to teach you. I don't want to just help you extinguish your mortgages, guys. I really like people who want to learn the process, so don't mind me, all right? This is how I teach. But if you are a grantor, that means you're granting something. That means, guess what? You are the one that funded this contract. And for those of you that get a little ahead, yes, this contract is a trust, and you should know where I'm going with this. So you're going to scroll all the way down in your deed of trust, and you're going to see this beautiful, beautiful section called transfer of rights in the property. When you get to this section, y'all, all right, it's going to read, the security instrument secures to lender the repayment of the loan in all renewals and modifications of the note.
Okay, let's see what she got to say about this.
I'm going to say that again. The security instrument, meaning this deed of trust, this security deed, this deed of trust, whatever the hell they want to call it, right? Secures to the lender the repayment of the loan. Stop right there.
It secures the repayment of the loan. This is where they get into their manipulation and the deceptive acts.
So you telling me the actual instrument itself pays for itself? That's exactly what this just told you. Y'all overcomplicated because you weren't taught how these things work. You weren't taught how to actually perform, okay? We don't pay for things around here. We perform our duties. Stay with me. You got to start learning what these words really mean, okay? So that means the security instrument basically pays for itself, y'all. That's exactly what this means. All renewals and modifications of no note. It don't matter what they do, flip flop, whatever they want to do with it. It pays for itself. Fact check me. Y'all know how I roll. All right, the continuation.
All right, we're going to stop right there. We'll come back to it. Now, let's come down here. So, she said hypothecate. Right? So here's your root word right here. Hypothec. Hypotheca. All right? So we're going to start at, that's 952. We're going to come back to that because she is talking about something else. And then we'll come down here. And then we had hypothecaria, hypothecate, hypothecation. We got hypothecation bond. So we got 952 and 953. What we're going to do is we're going to come up here and talk about grantor. All right, that is 652. No, it's not. It's 905. That's my donor. All right, let's go over here to grant. She said the grantor, right? To grant something, to bestow, to confer upon someone other than the person or entity which makes the grant. All right. We don't hear transfer yet. It's not in there. So in this court case, it says a conveyance. Now, this case says transfer of property, real or personal, by deed of trust or writing. So deed or writing. So a deed and writing could be considered to be synonymous in this situation dealing with grant. A generic term, also a generic term applicable to all transfers of real property, including transfers by operation of law as well as voluntary transfers. A transfer by deed of that which cannot be passed by livery. We don't know what that means. Let's write that down. An act evidenced by letters patent under the Great Seal, granting something from the king to a subject. Ooh. All right. Now, private land grant. Let's go grant and demise. Let's go to grantor. So grantee, one to whom a grant is made, Commissioner of Internal Revenue Service versus Police Chief. Grantor, the person by whom a grant is made. So now we know what that grant is. It's a transfer or conveyance. Conveyance, transfer, to bestow, to confer. This is pretty much what we consider to be a grant is. All right. Now we're going to go over to 652. Right. We're going to go to donee. Okay. One who is invested with a power of appointment. Donor, the party conferring a power. Remember, in grant, it said confer. So here's the donor, same situation. To confer, someone conferring a power, to confer power. So when you're looking at grantor, the confer means conferring power. One who makes a gift, one who creates a trust. Now, she did say, and she did state that they did create a trust, which is a deed of trust. So in that deed of trust, this is what we was talking about, beneficiaries, trustees, and how the thing is all set up. But the one thing that she left out, right, and she went into RESPA and all these things, we're going to get back into that, is what she's not bringing into the fold is that deed of trust still needs to be negotiated. There needed to be a counterclaim. Hey, is this the only trustee that could be on the deed of trust? Are you the only beneficiary? Is there any other beneficiaries that can be added to that? They'd be like who? Like my wife or my husband or my children. You know what I'm saying? How about that? Can those be added? This is a deed of trust, and this is real property. This is where we're going to be living. This is what we consider in our ownership. We own this, right? We're receiving this from a previous owner to us based on this price that we just paid. So when we're owning this and we have this deed of trust set up, how is this supposed to be set up? Is this the only way is it to be set up? And what are the conditions of this? Because if anything, if I'm signing anything that I have no rights entitled to, and I'm shifting and all the rights entitled over to you, then I want to know, what am I getting out of it? Nobody asked that. All right. Now, donation, a gift. But right here we got he to whom lands or tenements are given entail. So donatio, right? So we see right here. Oh man. Now right here it says, he by whom lands were given to another, the party making a donatio. So here this is a Latin term Donatio, a gift, a transfer of the title of property to one who receives it without paying for it. The act by which the owner of a thing voluntarily transfers the title and possession of the same from himself to another person. Without any consideration. All right. So let's look up these three words here. Consideration, entail, all right, let's look up those things. And we're going to also look up power of appointment. Power of appointment. Because the bottom line is when the district attorney picked up that case in regards to the state of Carolina, and they picked up that case, they brought it in the name of the state of Carolina or the county of whatever, which is still the state of Carolina, South Carolina, I should say. You know what? They put themselves in a position of a fiduciary, and they fall under the Power of Appointment Act. Now, let's go over here to consideration. We're just going to go in alphabetical order. Let's go to consideration. Look at all that. Consideration. Contracts. Look at all these different definitions for consideration. Look at all that. 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 Then you get to the Latin term. Let's keep going. Yeah, right here. Okay, consideration, a technical term indicating that a tribunal has heard and judicially determined matters submitted to it. That is consideration. In contracts, the inducement to a contract, inducement, the cause. Hold on. Got to plug the battery up. All right, hold on a second, y'all. Hold on a second. Hold on a second. Hold on a second. And you know what? I'm reading it to you. Okay? But let's go here so you guys can see it. Let me get the whole screen up. Let's get the whole screen up. My apologies. Again. All right. Consideration in contracts. We'll come back to donor because we're going to come back to donor. We're going to come back to grantor. But let's read these definitions, right? So the inducement to a contract. All right. So inducement. What does that mean? So where are we at? 455. 455. All right. We're going to come back and work this here. Let's come back here to the scroll down. All right. Let's go to inducement. All right, so let's go ahead and do this, and I guess I can. Maybe that'll help me focus when I know I got my video on. I ain't got to relax. All right, so look. Hey, what's going on, Tamula? Greetings, greetings, greetings. All right, so let's get back over here. This is important. This is important. I don't know if you guys understand how important this is. This covers everything. When I mean everything, everything. Covers everything. You guys understand this, you can win. And not spend a dime. Sheesh. Why do you guys think, quick sidebar, why do you guys think that they want everything to be done online now? Why do you think they want everything electronically done now? Why do you think that they're, even when you go into the bank, they're trying to send you to the website? Everywhere you go in doing these things, they want it to be done online. Why can't you get a paper bill anymore? Why can't you do that? Why are they inducing you? Just want to use that word. Why do they want that to happen? Exactly. They don't want to look at you. All right. Okay, here we go. To induce. To bring on or about, to affect, cause, to influence, to an act or course of conduct. Lead by persuasion or reasoning. Incite by motives. Prevail on. Inducement in contracts. The benefit or advantage which the promisor is to receive from a contract is the inducement for making it. In criminal evidence, motive, that which leads or tempts to the commission of a crime. In pleading, that portion of a declaration or any subsequent pleading in an action which is brought forward by way of explanatory introduction to the main allegations. Now, did they do that? Did the DA's office do that in that issue in the state of South Carolina? They do that? I don't know. We have another key word here, promisor. So let's go over here to promisor. And while we're there, we can look up power of appointment, promisor. Because we got to come back here to consideration. Induce. 999. All right. Let's go over here to promisor. All right, here we go. Just going straight to promisor. Okay, one who makes a promise. All right, so let's go to promise. A declaration which binds the person who makes it either in honor, conscience, or law to do or forbear a certain specific act, and which gives to the person to whom made a right to expect or claim the performance of some particular thing. A declaration, verbal or written, made by one person to another for a good or valuable consideration. In the nature of a covenant by which the promisor binds himself to do or forbear some act, and gives to the promisee a legal right to demand and enforce a fulfillment, an express undertaking or agreement to carry a purpose into effect. So, if we're going into consideration, right? So this is our best definition right here. Declaration, verbal or written, made by one person to another for good or valuable consideration. So that means that promise to pay is valuable and good consideration, right? Right. If you don't know, That's what it is. Now we're going to go right here to power of appointment. What is promissory? We have 1454. All right. So what we have right here, we're going to go to Power of Appointment Act. Power. There we go. All right. Power. The right, ability, of faculty of doing something. Authority to do any act which the grantor might himself lawfully perform. Authority to do any act which the grantor might himself lawfully perform. All right. So in a restricted sense, a power is a liberty or authority reserved by or limited to a person to dispose of real or personal property. Dispose of real or personal property for his own benefit or benefit of others, or enabling one person to dispose of interest which is vested in another. So real property law, an authority to do some act in relation to real property or to the creation or revocation of an estate therein, or a charge thereon which the owner granting or reserving such power might himself perform for any purpose. All right, so now general powers, executive power, general and special powers, power and gross, power of, no. Power and gross, applied powers, law of corporation power. They don't have, oh, there we go. Power of appointment, a power or authority conferred, there we go, by one person by deed or will upon another, called the donee, to appoint, that is, to select and nominate the person or persons who are to receive and enjoy an estate or an income therefrom or from a fund after the testator's death or the donee's death or after the termination of the existing right or interest. So this is why the banks have themselves in there as beneficiary. They are taking a place as the donee. I know this is getting complicated, but this is where the deception is. Right? You remember, we understand fiduciary relationship. A power or authority conferred by one person by deed or will upon another. All right, so we got that correct. These are how the, I'm trying to slow down a little bit so I don't talk over anybody's head here. All right. From what we see right here, we see that based on what the young lady was showing, is this power of appointment is dealing with a donee. The donee you usually consider to be the beneficiary in a trust that is created. Now, in that relationship with the mortgage, that deed of trust is set up in a way what you would consider to be a resulting trust. Implied trust. It's implied, it's resulting. What is definite is who the trustor is, who the grantor, who the donor, settlor, creator is, right? And that is through that promise, that promisor, that promise. That promise is what gave valuable consideration. Remember the New Deal, 1933. Remember negotiable instruments, bills of exchange, promissory notes. Remember all of that. Remember the suspension of the gold standard, Article 1, Section 8, Article 1, Section 10. More importantly, Section 10, all debts are to be paid in gold and silver, which we don't have because public policy has taken over actual private land and private ownership. Barter exchange, broker barter exchange. All right, those things have been overtaken by public policy, but within that public policy, you know that the government is now liable for all debts, public and private. And in legislature, the Article 1 is the trustee. And Article 2, the executive and the judicial are supposed to carry out any enforcement of any breach of that trustee or breach of that fiduciary duty. All right. So let's go to Intel, because we're on donor here. All this is stemming from donor and grantor. All right, let's go to Intel and inducement. All right, let's go there. I'm not looking at the chat, so I don't know what's going on. I don't know if anybody's there or not, but the show must go on. But we already looked that up, right? Inducement. We already looked that up. Yep, we did. All right, so Intel. So we got to come up to Intel. Those are two words. And not here. It's not here. All right. So now we got to go find tail. Let's find tail. All right, here we go. Boom. Okay, so here we go. Tail is state, Intel. And it's so this is an estate in tail, an estate of inheritance, which instead of descending to the heirs, generally goes to the heirs of the donee's body. Goes to the heirs of the donee's body, which means his lawful issue, his children, and through them to his grandchildren in a direct line. So as long as his posterity endures in a regular order and course of descent, and upon the death of the first owner without issue, the estate determines. Okay. So this is what it means by entail. So that means as long as the posterity endures, Did you guys just get that, Did you guys get the that you got the Is that these people are bringing you in, inducing you into some promise to grant and convey, donate, create, settle, grant your energy, the promise, the instruments, and everything. And while you're doing that, they're inducing you to sign off on something that they created in that trust, that deed, to make them beneficiary of it. And they're their posterity. So they want to attach to your estate. I'll be damned. Very good. I've said it other ways, but I want to say it this way. If they're in a position of beneficiary, they're saying they want to be attached to your posterity, not just yours and you from the start. That's yours, your father's, your mother's, your grandfather, and everybody going forward. All that energy that comes through that posterity, they are creating these indenture contracts to hitch to your stall and get tenancy to be able to lamp where you're at in your estate, your property, your land, everything, and make money off of it. And you're paying them as a beneficiary, like they're doing a service, right? As a servicer, they are considered servicers. And in the same sense, they're working for you. And you're paying them to work for you. And at the same time, everything else that comes through that in that full deed of trust that you're reading, that full promissory note, because I showed you in SAC Law on the website that promissory note, deed of trust, one and the same. So this is what they're doing. Now, I knew that, but how do you address that? How do you assert it in law and be able to recoup? Because if they're getting something, if you file, let's say, a 1041 or 706, 709 or whatever, depending on what you're filing, and you have beneficiaries on your Schedule K for 1041, you got your Schedule K1, 1041, and, with the 706, that's just one form and it has different schedules. And then the 709 is the same thing, but they're just titled. 706 is more just with estates and trusts, and the 709 is United States gift tax return. And the 706 is state and trust tax return. But you report who's receiving payments. You say, well, if they're servicing and they're saying that they're the lender, they're the creditor, and they are operating within that deed of trust, then that means that they are saying they are the beneficiary, the assigned beneficiary, or the initial beneficiary of that trust, because it is a trust. Now let's go back to, we got to do one more thing, livery. Let's take this down. Livery. What you guys gonna know that the people that still that I ain't even looking at the chat, but the ones that haven't moved, they're still here. Know what I'm talking about. Already own. Here's livery. So, livery. In English law, delivery of possession of their lands. In English law, delivery of possession of their lands to the king's tenants in capite or tenants by knight's service. So, livery. A writ, a particular dress, the privilege of particular guild, a contract of hiring of work beasts, feeding, stabling, livery conveyance, a vehicle used indiscriminately in conveying the public without limitation to certain persons or particular occasions or without being governed by special terms. Livery in chivalry. In feudal law, the delivery of the lands of a ward in chivalry out of the guardian's hands upon their heirs attaining the requisite age, 21 for male, 16 or okay. So that's livery. That's 1160. 1160. And hold on, I gotta go back to tail. I didn't write that down. Hold on, let's go back to tail. There we go. All right, 1700. All right. So you guys got those. Hope you guys taking those down too. Especially if you got Black's Law. You look these things up. You have that line. There it is. Now let's go back to donor. Let's go back to donor. All right. All right. So what we got here is donation. All right. We have donatio. Let's go to our Latin term first. A gift, a transfer of the title to property to one who receives it without paying for it. The act by which the owner of a thing voluntarily transfers the title and possession of the same from himself to another person without any consideration. Consideration, promise, or you being the promisor, the one that's doing the donatio, the transfer, promise. Make sure you're the promisor. The deed of trust is equal to what? A promissory note. Follow me. Now, in that consideration, that promise is considered to be something that is transferred for value. So what is the value? It's equal and valuable in that transfer of the title, the consideration. So that means that transfer of the title, I heard what she's saying, but the transfer of the title from me to you, I'm the one that gave the consideration. You received it without any consideration. Meaning you brought nothing to the table. I know that sounded kind of different. You did, you received, like, okay, so if you're the bank, it's me. Let me rephrase this. Once I make that transfer, I'm giving you consideration, You get consideration. But what you receive it without giving me any consideration. You see it? Because they're saying they're loaning you money, right? Or you're saying you're loaning me money. You're the bank. I'm the one coming in, right? You receive that, and in receiving that deed of trust, I'm transferring title over to you. You're saying that I need to sign that based on the fact that you're loaning me $300,000. So if you're loaning me $300,000, I must sign this deed of trust and transfer all rights and title to the property. All right. So now what it says right here, transfer of the title to property to one, to the bank, to you, who received it, as you received it without paying for it. So if that's the case, how are you loaning me money? So if you didn't pay anything, how are you loaning me money? Because that's the easiest way to say it. I'm loaning you the money. I'm not paying you for it. I'm loaning you the $300,000. You get it? The trick. Terminology, words, status, right? Status. What is the status? They're saying they're the lender and you're the borrower. But it also says on the deed of trust that you're the trustor, grantor. Right? Consideration. Now, when we go over here, let's come down here to right here. So we didn't get here yet, but I want to go through these definitions first so we get into the tail and the gift part so we don't have to go to the gift, right? So it's literal translation. So this is literal. Gift. Now, everybody know what a gift is. They think about Christmas, birthdays, anniversaries, Valentine's Day. You gonna go get a gift. But by law, right? Because that gift, you're saying you're giving a gift because you're not expecting anything back. That's why I don't understand women sometimes. Quick sidebar. When they give you a gift, you better have a gift. If an occasion comes up that they know about, you better have a gift. That's coercion. But nevertheless. So it says gift has acquired in real law. In its literal translation, gift has acquired in real law a more limited meaning, being applied to the conveyance of a estate's tail. Now we saw what tail meant. So let's run quick. That's why I want you to get the numbers. So we ran back quick. 1700. Boom. Tail. In a state of inheritance. All right. In a state of inheritance, right? So here we go. So it said, gift has acquired in real law a more limited meaning being applied to the conveyance of estate's tail. So an estate's tail, so estate's entail is an inheritance. So the value of that, the bank is coming in as the lender, saying they're loaning you money. You got to sign this application, this letter of credit. You have to sign this deed of trust, this promissory note, and transfer all rights and titles over to us for this $300 that we really not giving to you. Actually, we're not buying it. We're not purchasing it. We're loaning it to you. So you just gave them a letter of credit worth $300,000. You gave them another deed of trust or promissory note worth $300,000. You transferred over to them, and then they sit there and they create on their books how much? $300,000. Based off what? Your transfer, your deposit. Remember old school days? People used to dance like that. Yeah. Think about it. Now, keep this in mind. See, because she's going to want you to sign up and do all this other stuff and then whatever, and do some other stuff. Yeah, we ain't doing that right now. This right here is free. Looking up in the dictionary, understand what it means, and getting a scenario to play. We role play. Right, this is what we get. Now, we clear? Hopefully. Now let's go over here to donor. We're on a deed of trust here. We're just dealing with a mortgage, a deed of trust. The party conferring the power. Remember, we looked up what power of appointment is. The power of appointment. The Power of appointment. Let's run back to power of appointment because they had to do with a beneficiary as well, a donee, right? Remember, power of appointment. I didn't write that number down, did I? Oh, let's go to 1700. No, let's go to 1451. 1451. Let's go up here real quick. Power. All right, here we go. All right, let's go to power of appointment. Straight to power of appointment. A power or authority conferred by one person by deed or will upon another, called the donee, to appoint. That is to select and nominate person or persons who are to receive and enjoy an estate, entail, by donatio, by gift. All right. To appoint, that is to select and nominate the person or persons who are to receive and enjoy an estate for an income therefrom, an income that is your monthly mortgage payments, or from a fund, that deed of trust, right? That trust, that deed of trust, that trust has been fully funded by what? The promissory note and the letter of credit and the endorsement thereof, and through the Fed window, through your Social Security account and your certificate or your secured collateral on top of that, which is your foundation, which is the certificate of title, which is your certificate of birth. All right. All these things are fully bonded. So you multiply that. You got 300, 600, 900. 12, 1.2 million, 1.5 million. Keep it going. Keep it going. Don't forget they ran your credit. That's another one. It's another application. Take a look at how many applications you have. And it's insured, right? By the so-called trustee of that deed of trust, which is title insurance company, i.e. Fidelity. For how much? $300,000. And you have escrow that open up. You have 3 escrows. You know, people say it's 1 escrow. But you have 3. Investor escrow, purchase escrow, creditor debtor escrow. All right. So we got it right here. So under there, after the testator's death or the donee's death, or after the termination of the existing right or interest. So here we go. So we're good. So that is what? 1410. 1410. Power of appointment. Now we're going to go back up here to 652, which is your donor. We have the donee right there, but we want to deal with donor status. The party conferring a power. Now let's go to confer. I don't know why I didn't do this. Let's go to confer. Make sure we got this right. This thing has, I don't know why it ended up doing that. Man. All right. Confession, confer. All right, here we go. Confer. No? No confer. Damn. Confer. All right, we got to come here. Hold on. I got my Webster's new. Okay, so this is copywritten. All right, let's see if confer is here. I brought this up just in case I needed to have a backup. Nope. No confer there either. All right. So we got to come over here and we got to look up what confer is. All right. So what we got right here? To bestow, to invest with, to meet in order, to deliberate together or compare. Confer in real estate. All right, confer in real estate, discussions or meetings between parties involved in a real estate transaction, such as buyers, sellers, and agents, to negotiate terms and make decisions. So, if we have that, if that's proper, so purpose of confer, negotiation, decision-making, clarification. So, what I'm gonna ask right here, so what is conferring power? Let's come back over here, Black's Law. What is conferring power as defined in Black's Law? Definition of donor. All right, so what we got right here? Black's Law Dictionary defines donor as a person who makes a gift. Conferring power equals authority given by the donor to someone else over the subject matter of the gift to manage, transfer, revoke, appoint. So in a deed of trust, if I was to actually show the deed of trust, right? I'm going to show you a deed of trust. I got to redact it. But under the circumstances, if that's the case, if the donor is given authority to someone else over the subject matter of the gift, which is the promissory note, right? Because the deed of trust is the promissory note. To manage, transfer, revoke, appoint, etc. So the appoint, manage, transfer, the transfer of things. So that is who doing what? Is that fidelity during the Schedule A of the land title insurance? Are they doing a transfer right there? I don't know. Seems like it, because in the deed of trust, they are considered to be trustee. And the bank is considered to be the beneficiary. So who is actually in control? Who's running the issue here? Because we know that all things are ran through insurance. If you got an FHA loan, HUD, or fair house, first-time home buyer, whatever, everything within FHA, people don't say that, but actually the federal government does guarantees these loans. So we got a clear idea now, all right? So that is what confer is. Conferring power is authority given by the donor. So that's given authority. So now let's read it this way. The party giving authority, right? Given authority or conferring a power, granting authority. So the party granting a power. Roll with that. One who makes a gift. Well, we got that. So we got donatio. One who makes a gift. One who creates a trust. He who gives lands or tenements to another entail. So So the deed of trust, everything that we're looking at right now, is going to the deed of trust. So we looked up definition of what tell is. We looked up what donatio is, to donate. We saw what a gift is. We know what the trust is. So this is a whole scam. And the one thing that's left out is the endorsement, because the endorsement and the conferring part. So to confer, it means that you had a meeting of the minds based on what this definition is saying. This definition is saying it refers to discussions or meetings between parties involved in a real estate transaction. Well, what was the meeting and what was the conversation? What was the discussion had? Yeah, you need to fill out this application. I need your ID. I need your social security number. We need to run a credit report. I need 2 years taxes. I need your W-2s or 1099s or whatever, pay stubs. We need all that right there. Boom, 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 boom. We need all that before we get started. And then we'll see we need to run your credit report, because we need to see if you are credible enough. Remember, we looked up what credible means. We're credible enough for us to loan you money. Right. Okay. Now, this is what we have here. This is what they tell you. But we just looked up these terms, right? So let's go back to grantor. So we're straight. That's what, 905? Well, we saw donee. And what I want to do, I'm going to bring up this other definition of donor, because it gives some more definitions. 905. 905. So we saw grantor, the person to whom a grant is made. Grantee, one to whom a grant is made, one to whom a grant is made. Grantor, the person by whom a grant is made. Grant, to bestow, to confer. Right? Upon someone other than the person or entity which makes the grant. That is the grantee. Grantor, grantee. Deed, transfer of real property, deed of trust. Transfer of real property or personal by deed or writing. So here we go. There we go. A transfer by deed of that which cannot be passed by livery. Now, here we go. We're going to tie it together. What is livery? Let's go back to livery. What number is that? So the transfer by deed of that which cannot be passed by livery. So whatever this definition is, the deed cannot be transferred if it is passed by livery. Let's see what that says. Livery. Oh, livery. Okay. Livery. In English law, livery of possession of their lands to the king's tenants. In capite, or tenants by night service. A writ which may be sued out by ward. In chivalry, we know what chivalry is. A particular dress or garb, the privilege of a particular guild, a contract of hiring of work beast. So if you have a 30-year mortgage, right, that is tied within this deed of trust, then what we have here, and we'll look at the deed of trust in detail on another occasion. But if the number 5 definition is a contract of hiring of work beasts, particularly horses, to the use of the hire, then if you if you have 30 years mortgage, that you have 30 years to pay this thing off with interest, and you're doing what? Mowing the lawn, you putting improvements on it, paying the bills, you know, utilities and all the different things. You got to make sure that it's fully furnished. You know, you got to do the daily operations of everything, you know, all these, you got to take, you know, garbage, whatever needs to be done for 30 years while you're still paying on that promissory note. Wouldn't that be considered you being a work beast? I don't know. I mean, I feel that way now. I feel like they have been treating me like a work beast. A horse with no buggy. I don't know how you guys will feel, but looks like that to me. Number 6, feeding, stabling, and care of horses for pay. Boarding, as to keep one's horses at livery. No. Livery conveyance, a vehicle used indiscriminately in conveying the public without limitation to certain persons or particular occasions without being governed by special terms. Livery and chivalry, the delivery of lands of a ward in chivalry out of the guardian's hands upon their heirs attaining the requisite age. So there's the chivalry part. So which one of these liveries applied? I think they all could apply, except for the dress. So in the contract, if you read it closely, that contract has a lot of this type of language in here. Livery and chivalry and livery conveyance. A vehicle used indiscriminately. So this deed of trust, right? You see a deed of trust. You're the trustor. Fidelity is the trustee, which is escrow and title insurance company. The bank ABC is the beneficiary. Everything looks right. We're loaning you money. The application, a letter of credit, right? Because the applicant is one who extends letters of credit. The application is the letter of credit. The endorsement in blank or special. Also, what we have here is what else? We have a grantor, we have a trustor, settlor, donor, creator. We also have something that is considered to be a promise. We also have power of appointment, consideration. All that has been done on your end. You have provided all the energy has been shifted. They have done nothing but do what? Tell you something. And at no point in time in any of those instruments, you're going to see any signature from anybody from that bank. So if this has been done in chivalry, if there's been livery done in chivalry or conveyance, then what does it say? What does it say? A transfer by deed of that which cannot be passed by livery. New drink. Livery. So this must be applied, right? To the ones listening to me, that know what I'm saying. This has to be applied. So if any of these instruments were now produced by livery, and all these transfer things was done without full disclosure through deceptive practices. Deceptive means by misrepresentation of material facts that, number one, you said you lent me something, that's fair debt collection practices, along with truth in lending, RESPA as well. it falls under real estate settlement procedures, that you presented yourself, you identified yourself as a lender or a bank that lends money. Violation. Truth in Lending Act. You said you loan money. No, Truth in Lending Act says you extend credit. The other thing, you didn't reveal that this actually was a negotiable instrument and that this was considered to be payment. So in the transfer is also a deposit, a transfer of assets from one end to the other. Assets come to me, you provide me the application, I fill it out. You provide me another application, I fill it out. You provide me another application, I fill that out. And I endorse all of them. Shift them over to you for processing. You then create $300 on your books based on the deposits that was transferred to you, because banks state, and I've showed it, that banks create funds and create credit and create loans from the depositor's deposits. So let's go back to donor. And what we're going to do also from there, appreciate y'all being with me, whoever's there. I am in a zone. I'm not looking at anything right now. Let me come back over to y'all and say what's happening. Okay, cool. All right. What's going on, J-Dub? Yep. What's going on? Original RCJ. The Adept Moore. What's going on, my brother? Peace to you. Hit the like, share. You know what I mean? Repost it. Hopefully it's something. I'm going to put the link in the chat real quick. What is it, 420? Yeah, let me do this real quick and we can stop right here. It's 420. So that's what am I on? 2.5? All right, that's cool. That's cool. All right. So let me do this real quick. Let me come up here. Let me take that down real quick. Let me go to my other definition. Let's go here. No, that ain't what I want. All right. Let me put the link in the chat right now while I'm thinking about it. All right, we spin to the top two. Let's bring it back up. Boom. All right, so what we have here is we have donor. We have other ones that we have here as well. Here's some other definitions that you might know existed, right? So you see donee. Same thing, we got the donatio there. We have donee beneficiary in a third-party contract. Now we know that banks on a deed of trust are going to be in the position as the beneficiary. The title company / escrow, who creates the land title insurance, or what they also call lender's title insurance. It depends on what it is. You express it that way. If you don't, everything is already assumed as resulting, implied. Donee of power, the person to whom the settler or donor of a power of appointment gives such power to be exercised. That's why I wanted you guys to understand these other definitions. Now, in a third-party contract, the person who takes the benefit of the contract though there is no privity between him and the contracting parties. Now, who is that? It's the bank. You know why? Because you have underwriters, you have loan originators, you have people in the back that they are going to, that is approving or denying these things when it's dealing with, being approved for a loan. It ain't the bank. The bank is servicing the loan. Remember that. So in this is a third-party contract. The bank is the third party. That's why they're in a position as the beneficiary. The trustee, meaning the title insurance company, are involved in making sure this transfer. That's why the grant deed, if you look at your grant deed that comes from the previous owner, actually is the one that has your grant deed from the previous owner. The original signature. Now, the person to whom the settlor or donor of a power, now we get down here to donor of power. The person to whom the settlor, got a different term here, settlor or donor, so same thing, of a power of appointment gives such power to be exercised. So remember when I read fiduciary responsibility, this is why I hope you guys are taking notes if you're really trying to learn. If you're really trying to get this and know it for yourself, is that in the fiduciary responsibility in American jurisprudence, it says to be exercised and must exercise under every disability and prohibition. I didn't turn my video back on. But yeah, it says to exercise under every disability and prohibition. Now, what does that mean? Everybody know what a disability means. You know what I'm saying? If you're disabled, that means, that means there's certain things that you can't do because, something might be missing or something might be off. You know what I'm saying? Prohibition is like, you remember prohibition during the times of, the alcohol and all that stuff, where they put in prohibition. That's to prohibit something that's already set up, rules and regulations, right? Donovan versus Rodriguez. So if we have that right here, boom. This is more of an extension of what this donee is. So you see how they changed them over time, so that way it kind of left it, a little ambiguous. So it says in the case of a special power in favor of a limited class, such as members of a family, or in the case of a general power in favor of anyone, including the donee himself. I want you guys to see that. Now let's go look up settlor real quick and we're done. Let's go look up settlor. Let's look up settlor. Sheesh. There we go. All right, settlor. All right, settlor with the O, not with the E, with the O. The grantor or donor in a deed of settlement. So now we have what? Settlement. So that deed of trust also is a deed of settlement? Maybe. So that grantor or donor in a deed of settlement, also one who creates a trust, one who furnishes the consideration for the creation of the trust. So now you have Fidelity, you have Bank ABC, the trustee and the beneficiary. You've got the deed of trust, which is also a promissory note. You have a letter of credit that was done through the application, what they call a loan application. You also have an application, a letter of credit that was given for a credibility run for the Social Security number and the date of birth. So you have all those things lined up. You have escrow that has opened up through the title company, right? They run a complete title search, so they say. They also create land insurance, title insurance, which insures either the lender or the owner, depending on how it's set up. That then creates another encumbrance for $300,000. So with all those being there, there's at least $1.5 million sitting on the table. That $300,000 moved 5 times. But in this settlor definition, furnishes the consideration. So if I furnish you the consideration for the creation of the trust, that means it funded the trust. Have you ever heard these people doing these advertisements about trust and say, well, the one thing people don't understand is what it means to fund the trust. So how do we fund the trust? That promissory note is also in that deed of trust, that promissory note / deed of trust is also a security agreement. It also has, well, let me say it this way. It also has a security agreement section within that. It also has a hold, harmless, and indemnity agreement in that. Right, J-Dub? All those things. And it also has UCC language in there. It also has, well, in regards to Article 3, Article 5, Article 4, Article 8, Article 9. It also has consumer language in there. It pretty much covers every angle in that full promissory note. What is considered to be consideration. All right. Settlor. That is 1615. And we're done. And we're done. We're done. All right. All right. What's going on, my brother? Appreciate everybody being here. Appreciate the hearts to Mula. I did all right. Here we go. Everybody in the chat, if you're listening, above a 5, below a 5. Above a 5, below a 5. Don't need a number. You can just put an arrow up or arrow down. You can say above, below, whatever it might be. We're going from there. Now now J-Dub, what we're gonna have to do here is we're going to have to figure out. I mean, shit, we got a lot of paperwork to go through. We got to figure out how to get this stuff in order. I mean, we could easily just run it through, you know, our newly administrative assistant, you know who that is, and you know, put it in a summary and put it in an outline throughout the you know, throughout the outline. I mean throughout. Let me use another word. These definitions, because the one thing that is avoided, and even when I actually push that language, the trust language, And I pushed the other things, it was totally ignored. And I think for the simple fact that, initially, it was the circumventing. It was the circumventing. And, initially what I didn't do is I didn't recuse the judge. You know what I'm saying? I didn't recuse the judge. You see what I'm saying? So once they move forward on that, then they say, okay, we established jurisdiction and we can do what we want. And then they're looking at everything.
So you're supposed to recuse the judge before they make the move on you?
Exactly. So I would say, California, the peremptory challenge, right? So the peremptory challenge got 170.1, 170.4, 170.6 for cause, right? So before any hearing takes place, you can remove a judge for cause.
Well, check it. Interesting that you say that, because a deal just came on today. The homie was looking at another bar. I won't say the area, but it's choice area. It's in the downtown area, right? So he paid an attorney to give him the skinny on it. Come to find out, I guess it's in foreclosure, right? So I'm reading this, looking at this. I'm like, okay, so he just paid for this attorney to give him some information so he can go make a deal before it hasn't shown that the deed of trust has been perfected, or well, I don't know what the word is, but it hasn't shown the transfer, that the dulo hasn't been quite done yet, but they on the ropes.
Right, trustees deed upon sale. Yeah.
Yeah. So it hasn't been recorded, or it's not showing yet. So they're hoping that they can maybe go do some talking before. So would that mean that the owner or the grantee or grantor, the original purchaser, would that mean they still have a little play, or is it pretty much over when they start talking that grant deed trustee getting the grant deed, the powers over the grant deed? I mean, over the deed of trust, because that's where it sounds like it's moving to. I was trying to get it up again because it's like right on point what you were saying. I'm like, man, somebody's in this water right now as we speak, and it sounds like if they could have this information. I mean, but this is a business, a bar business, so
right.
Same thing though. It's the land, because you own the land too with this business, not just the liquor license. It's got food. It's a food and liquor license.
Right. Well, so what I would do is, if you can negotiate that, the quickest way to do it, and this is why I try to do it, this is how I do everything. And when there's distress involved with the land you're trying to help, and the dwelling on top, the best thing to do is go straight to them, see if you can get do some type of private contract, or if you got a real estate agent that's working with you to move fast. I almost was able to pull it off. Is give them a quick offer, tentative offer. Get them to sign that tentative offer. Once that tentative offer is made, then we could get into the rest. Here's my offer. Would you want to do that? Boom. I want to open up escrow for $1 right now. Let's get escrow open for $1. Bam, we dropped $1 in there. Escrow. Once we get that agreement, bam, get the contract ready. Let's open up escrow. We have a tentative contract, pending all the different things that got to run, all the different, title and everything, or even not even doing that. You get a tentative, you get escrow open, you get the agreements there, and then you have the contract ready behind it just to get that signed. Because once that tentative agreement is signed, now you have a contract before anything else is done. Then we can open up escrow and get title to run, and then be able to contact the people that's doing the foreclosure. That'll work. Now you can contest it, because you got the realtor. Now you can contest the loan, you can contest the mortgage and all the different things. Say, hey, make sure you produce everything. We need to get a payoff statement. We need to see all original wet ink signatures, so on and so forth. So that way we do our proper due diligence. Shit, they might owe like $500,000. After it's all said and done, it might come down to like 25, 50, 200,000 or something like that. Who knows? Might be able to get rid of the loan. Now, was this like a big land or something?
This is a bar and restaurant.
They going into foreclosure.
With the liquor license. Yes, the husband just died and the wife's being kind of difficult from what I'm hearing. I'm looking up the email, the text right now so I can give you exactly, because it's chewy.
Right.
It's juicy because it's right up on what you're talking about. I'm like, So my friend got an attorney involved. He spent a couple grand to get this information to see if he can get one leg up on this purchase, because he really wants to buy this this business. So this is what they said, just to give a little, okay, here we go. So I'm not going to say his name, but he says, boom, based on my research, there have been multiple notices of defaults recorded, then rescinded. The most recent notice of default was recorded on 2/27/26, not rescinded. The notice of trustee sale that you sent to me was recorded on 5/29/26 as documented number blah, 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 but has not yet been verified and is pending processing. So it is not showing on public record. While it shows a sale date that if you make an offer for the property, you would also make an offer to purchase the FF, I think that's the food or the FF and E, and negotiate the deal with the bank, get all liens released, etc. But again, the liquor license is a separate deal, and applications would need to be made to the ABC. I could not find a, there's more here, one second. Trying to get the whole thing into my phone slow. Okay, it says here, I could not, my guess is that, okay, where we go? The liquor license is separate. I could not find, man, my phone died. Shit. I was almost done with it. It'll come back up. I'll bring it back up again and finish it. But basically, I think he was trying to say he couldn't find a lien on the liquor license, and he doesn't believe a bank can lien on a liquor license. So, but it sounds like he's trying to tell him, you might still have to deal with the bank. Well, you got to deal with the bank, but the sellers are just asked out, because these people are, my guy's a hawk. That's what he represents, the vulture right now, with some trying to get at this.
It's just the liquor license. Oh, that's gonna lean on the business. That ain't gonna lean on the license. Now,
yeah, you can't lean on that license. That's what we're thinking. So that's just on the land and the business, right? The business, yeah.
Yeah, they might be able to settle with them. They might be able to settle with them for like maybe 50% of that. They say, hey, I'll pay off this right here. And you let them know, hey, we're going out of business.
Yeah. Or have him do a bankruptcy.
He can do a bankruptcy, but then you never know what happens with that liquor license.
Yeah, that's true.
Is the license attached to the loan, or is it the loan attached to the business? Is it attached to the business or attached to the license? You know what I'm saying?
The FF and E, I think, is food, and then liquor license. So I believe that they're separate licenses. So you could buy the building and not get the liquor license.
Exactly. Yeah, that ain't got nothing.
So but I don't think there could be a lien on the liquor license.
No, you can't put a lien on the liquor license.
That would be pretty diabolical.
The only way you get your license took is if you violate ABC.
Yeah.
ABC.
You got to qualify. Yeah, so that's just a little live one going down right now.
Oh, he good there. He good. They ain't got to worry about that. You can just help him out. Say, hey, I'll help you pay off your liquor license thing or whatever. Your
so
bill.
He could. There is some wiggle room left since it hasn't showed up. So this was from today. We got this little info. So
unless they agreed, though, Jay, unless they agreed that they could put a lien on on the business or on the property. You know what I'm saying?
Got it.
But
The lawyer was saying to get rid of all the liens. The lawyer was saying to get rid of all the liens and encumbrances, but it sounded like something already transferred. Well, if he said the bank was already involved in the get-go, so they was going to want their piece. So, but you're saying that it would be able to negotiate. Let's say just use it as a scenario where you're going in and try to get this person from not losing it, but you're going to get it from them, but give them a little more than what they were going to get, because they ain't going to get nothing right now the way it's going. The wife sounds like she's going to get nothing except after they pay off everything. It's only been shut down 2 months. So he just died. They want 1.3. It's right downtown. Good spot.
Man, there's two spots. No, there's 2 spots out here in Sac that I want to get. I mean, a bowling alley is closed down, and they selling that whole bowling alley.
Oh yeah?
Oh, was it a bowling alley? Yeah, it's a bowling alley. I think it's a bowling alley, or it's a skating rink. Man, shit.
Bowling alleys be having liquor licenses too.
Man, they say it's hard to get a liquor license.
Oh, really?
Yeah, they say it's hard to get a liquor license.
Well, they have at least a beer license. Some of them have a beer license at least.
They only give so many per city, per state.
Right.
So you most likely got to purchase someone who already has one.
Damn. I heard you can do that. They got to be a part of the business, right?
Nah.
Yeah, I heard that from somebody. Somebody told me that they got to be on the business.
Okay, so it says here, okay, let me finish this. Okay, so it said, the notice of trustee sale includes the property and FF&E secured by the bank's deed of trust and security agreement. The liquor license is separate. The property sale via Pacifica does not include the FF&E. My guess is that if you make an offer for the property, you could also make an offer to purchase the FF&E and negotiate the deal with the bank, get all liens released, etc. But again, the liquor license is a separate deal, and the application would need to be made to the ABC. I cannot find evidence that there is a lien on the LL, the liquor license, nor do I believe a bank can put a lien on a liquor license.
Exactly.
That helps.
Now the easiest thing for him, tell him this then. This would be easy. He could just assume the debt. Have him transfer everything over into his name, and he can continue the business with them guys. Obviously, doing business with the company.
And then just negotiate whatever the liens are. He just negotiate those liens off.
Yeah. He can assume the debt, pay it off, and then
bring it out of arrears.
Bring it current. Yep.
But that's by talking to the owner still, right?
Why would you get it play? Huh?
Does the owner still have play?
No.
The owner's out now, right?
The owner's out.
Okay.
Unless he works out something with them to where he say, okay, I'm gonna assume all this over here, you're gonna bring that price down off that thing. I'm gonna take over I'm gonna assume all your debts, get them all taken care of, but you're gonna come down on that price.
So that's how you go to the owner, come down on the price, and I'll assume the loans. But then you said assume the loan first. So was that going directly to the bank and saying we'll assume that loan and see what it would be to just assume it?
No, because all they're gonna do is whatever they owe and whatever they was paying on, that's what he's gonna be paying, and nothing changing.
Oh, okay, but that's the assumption. You're talking about assuming that whatever that obligation was, assume that obligation, right? Okay, and then but do directly with the bank or negotiate another deal where you assume it from the owner's level, but he got to come down on the sale price.
Yep, that's what you call subject to. That's another form of a subject to. I just use the subject to language in regards to doing that, because if, let's say if they want $1 million, you say, okay, what's your outstanding debt? Everything you got on this business right here. Okay, here's what I'm gonna do. I'm gonna pick all that up, but you're gonna come down on that price. Now he knows he got a lawyer. He can negotiate all that stuff and get that shit down for pennies on the dollar, because it's bad debt already, probably.
Yeah. Yeah. So just if he come up with half of that shit, they'll probably take it.
They would.
You know, and then give those people, tell them to come down, you know. If he comes, like you said, 300,000-400,000, they want 1.3. If they come down below.
Yeah, he can even probably refinance that, whatever. He could probably refinance that whatever that debt is on because what they did is they probably took the liquor license, you know, they got to get a bond for it, they got to get insurance, so they took that and probably borrowed off of that, and then that borrow of that thingamajig, you know what I'm saying, is where they got the money. I don't understand why.
In that deed of trust, well, they said they can't lien on a liquor license, so you probably have to lien on the business attached to that liquor license, but because that's what he was saying. He don't think nobody. So I don't think you could put a private lien on it. You can't put no bank lien. I don't think you put a private lien. You can put, you know, some hard money, but you know that might get your fingers chopped off. So I don't think he's talking about that kind of money or that kind of lien.
Right.
So this one is all paper. So I believe, probably just the bank would be that. Yeah, they might be able to be negotiable to get that bad boy down. But the bank sounds like they can't negotiate the lien. I mean, the liquor license. Like, that's still the owner's. The land he losing. He can move that liquor license. So that's the value, is the liquor license. So but he can move it, and it sounds like it's food too. It's FF&E. So I think that's food.
Yeah.
So yeah, this is interesting. So you see how you have so what do you call these kinds of attachments to the actual land? Like that they don't really belong to the land, that they belong to the business or the owner. It's a separate owner. It could be a separate owner that has the liquor license, and then they could license that out to whoever the land owner of the land is, or they could be one and the same. But sounds like you can lien on a liquor license. That's pretty interesting.
Right, and I just look up that FF&E. That's furniture, fixtures, and equipment.
Oh, the furniture. Oh, everything in it. Okay. So furniture, fixtures, and equipment. Okay, great.
So that means they took a loan. Like you go to like a wholesale type. You go to a wholesale place that just sells. Because I've been looking into all the different things to open up a restaurant anyway, because I want to open up a restaurant and a store. And so when you go to these places, like especially the furniture, fixtures, and equipment, you know, you can actually, you know, rent. You know, you could lease them. You ain't got to buy them. You could just lease them. And then when they upgrade, you just bring it back. It's kind of like leasing a car. You just rent, lease, and then come back and then, you know, exchange them out.
This deal's coming with it, though. It sounds like it comes with it, that part. But it's separate from that liquor license. He just made sure. It looks like it's 3 deals. The land, the land, the building, the furniture, fixtures, and then the liquor license.
Right.
And then the food license.
Right. Yeah, so they pretty much got a loan on all of those things.
Like a bundle, but the bundle tied up, it somehow got a deed of trust on their real estate, which now is attached to the land. So they can't do all the other things unless, you know, they could, but it's a little too late to do all those moves you're talking about. I don't want to say late, but you know what I mean. These people are swarming to go buy his shit on City Hall as soon as possible.
Right.
On the steps.
Right.
But it sounds like the bank already got the deed of trust, so that means they already did the City Hall steps. Because sounds like the bank got the transfer back to them, and they're just waiting for it to record.
Right.
Yeah, man. So that's a business. Make a good 10, 15 on the weekend, on the Friday, Saturday.
Yeah, it might. I think it sounds like it might be real simple for him. He just need to understand where everything is at. So you do a bundle package, shit, he can get that on the low.
I don't know how long this phone gonna go before it starts staticking and shit. So,
you keep falling out too. Go ahead, bro.
There you go, staticking. No, pull up that link in the back. I just put it in the back right quick and read that.
All right, hold on. Let me pull it up. Okay, Alien Registration Act. This alien registration requirement. This is at the Temple University. All right, where are we going? From the top? You start right here?
Yeah.
All right, new USCIS guidance. Hold on. What is USCIS? United States. Hold on. I need to know what that means. Hold on. USCIS. I know that has something to do with immigration.
I mean, Customs, United States Customs Service, immigration.
Oh, United States Citizenship and Immigration Services. Okay, got it.
There we go.
All right. So, new United States Citizen and Immigration Services. What did it say? Yeah, services.
United States Citizens and Immigration Services.
All right. Guidance will require young non-immigrants who turn 14 while in the U.S. to re-register with the USCIS within 30 days of their birthday, even if previously registered when entering the country. This may affect, for example, F2, J2, H4 dependents and young F1, J1 students who entered before age 14. Non-immigrants who entered the U.S. at age 14 plus are already automatically registered as evidenced by their Form 1-94 and don't need to re-register.
Just don't have nothing to do with the non-deportables.
Okay, so talk to me before I go any further. What we got going on? Oh, he fell off again. All right, what we got going on there?
Read that first line.
I did.
I didn't hear it.
You fell it off. Okay, so new USCIS, that's the United States Citizen and Immigration Services guidance, will require young non-immigrants who turn 14 while in the U.S. to re-register with the USCIS within 30 days of their birthday, even if previously registered when entering the country. All right? What we got?
How does a non-immigrant enter the country?
Well, we about to find out.
What I've been trying to.
Does he fall down on his head and he sees stars? He's sticking somewhere else?
You breaking up, Naughty, you breaking up.
Yeah, we can't hear you at all, man. It's real bad.
You break it up real bad.
Go out and come in. When I come back in, y'all gotta keep quiet because when you start talking,
you got to explain that one. You're right. A non-immigrant might already be registered too. What? Before he entered the country. How? So they must mean
you're a non-immigrant when you're born. You're not in the country of the United States. You're an American, identified as an American nationalist until you do your birth certificate, and that puts you as a registered U.S. citizen. Then you get to come in when you turn 14. It used to be 5, and I moved it up to 14 now.
Bring that back, Anton.
Hold on. Naughty is breaking up, man. I can't hear what he's saying.
Yeah, but I know I heard every other word, but it sounded like the guy we were non-immigrant at birth.
Yeah, hold on, J-Dub, hold on. Hold on. Naughty. What was the last part you said? You said that's why you got it. It used to be 5 years, but what now? All right. All right, let's bring this back up. Okay, so USCIS guidance will require young non-immigrants who turn 14 while in the U.S. Well, we got to look up and see what a non-immigrant is.
And where the U.S. is.
Hold on, man. Hold on. We start trolling this brother, man. Hold on. All right, so non-immigrants are foreign nationals. Let's see if he came back. He didn't come back. There you go. Bam. Mic check. Mic check. Naughty. Mic check. Mic check. Mic check. Mic check. Mic check. Mic check.
That's still crackling, man. I can't do it.
Yeah. All right, hold on. Let me read this definition of non-immigrant. Non-immigrants are foreign nationals who enter the United States temporarily for specific purposes such as tourism, business, study, or temporary work. They must demonstrate that they do not intend to stay permanently. Common non-immigrant visa categories include B, visitor, F, student, H, temporary worker, and J, exchange visitor.
Yeah. Wow.
All right.
I don't see the connect there because where would we connect to that?
Well, we could connect to it. Okay, technically, we could be connected as a visitor.
But where's we don't need a visa though?
To the United States, right? To the United States. Remember, the United States isn't the whole America.
I got you, but remember still that visa part. See, there's still no when do you immigrate? See, when do we get involved with that international part of, like where you can't come here until you fill out some forms? We never fill forms out except for an application that our parents fill, and we don't fill that out. If we never sign our name to nothing again in life, you can't be deported. So I don't understand how it would fall in line with like visitor. I see visitor, but everybody temporary, nobody permanent on this earth. So what do they mean? Yeah, we can be temporary. Okay, everyone is.
Okay, but wait a minute. Let's deal with the function. All right, let's deal with the function of it. Okay, so we could be considered temporary, but if you're dealing with a visa, if you got a passport book, right? If you got a passport book, it does.
You don't need it. No. When you're born, you have a birth certificate. That's your first registration. That's what's making you a non-immigrant.
Then that's the passport. You're saying the birth certificate is the passport.
The birth certificate is
passport.
It's more than.
Wait up, hold on, man.
I can't say nothing. Stop interrupting me. The birth certificate is an acceptable document for the I think it's it's that form on it's that form on the thing. Whatever number this is.
The I-94.
No. The other one.
Okay.
All right, so all right. Now we know that you can actually travel with your birth certificate. You can travel with that. You can get on an airplane, train.
It's gonna be 8 USC 264. So this is an acceptable document to coincide with this immigration code right here. 8, you got to see the immigration code, Title 8, it applies to you as well. Just because it says alien and immigration code, it applies to you. So you can, this is where you get your national identity. This is where you get your citizen identity. This is where you get your diplomatic identity. This is where you get your identification as a government agent, you or your kin identity. So a lot of people say they Indians, they will fall up under a family member to a foreign government. So they will be have the ability to receive a diplomatic immunity in the United States because you're representing a different government, a nation within a nation, and we don't understand that. But they identifying you as a nation within a nation. They identifying you until you come into the jurisdiction of the United States, which is separate from America. It's not America. It's not no tribes, no nothing. It's its own independent foreign corporation. That's exactly what it is. So when you are joined to it, it tells you this rule used to be till you was 5 years old, you had to correct your status. But this is part of the correcting the status identity that you're not seeing. People not seeing. So when you turn 14, all the way from 14 to 16, until you get a driver's license or even older, then that's when you're gonna you're really moving against the law, right? At this point. So they really giving you 2 years. It used to be from 5 to the age of 5, but they didn't moved it to 14 now. They constantly moving it.
All right. So how are you? I mean, you're 5 years old. 14, 16 years old. How you know?
You implementing your status. Shit.
You're not getting this information in school. The parents aren't getting this information in either. They're not. Yeah, but is that being delivered to people's homes? No, it's not being delivered to people's homes. Nobody knows this shit. So that would be considered entrapment. Hold on. Going somewhere. This is what I'm talking about, status and entrapment. That's entrapment. If you know that that these people, we are not, just deal with us right now, that we are not citizens, and we're coming into the United States as foreign nationals, a nation within a nation or a government within a government, then I think they need to let us know that. So that way we can do the proper things to give notice, just to give us notice.
You got to remember that.
You need to file your taxes.
Hold on. You got to remember that the educational is allocated through the states, medical through the states. So it's the state who's teaching you state shit and some government shit.
Man,
it's not the federal government purpose to teach state citizens shit.
Come on, man.
I don't know why we keep going into this. It's open to the public.
Hey, they can't have it both ways. How the fuck they can't have it both ways, now? Come on, man. Something that needs to be done that will actually make business good in the United States and get rid of all the bullshit where people say, okay, we got everybody straight. We got us straight. We got children straight. We get business. We come in there on a temporary basis because when we come in and work, or we fill out a W-2, or W-4, 1099, we're working for a government agency. So that's city, county, state, federal. That's the only places that we're dealing with. We ain't talking about a private company, a private corporation. We're talking about a federal, state, county, city, local ordinance, department, agency. Now, if that's the case, then they need to be given that in that job description. But if we're working for another a private company, why are we all of a sudden? This is where things get messed up because I deal with taxes. The bottom line is, if you're working for a private company that is not associated with the United States government, you shouldn't have to fill out a W-4. You shouldn't have to fill out a 1099. At best, you should be filling out a 1099-B. or 1099 NEC, non-employee compensation, pay a recipient. You see what I'm saying? I mean, I'm just saying. Come on, man. They can't have it both ways. That's manipulation. You got it. Go ahead, now. Thank you for letting me get that off, because boom, that was a red flag. Mic check. Now, you there?
Yeah, I'm here.
Okay, you heard what I said, right?
Some of it, yeah.
Okay. Well, we know for a fact, undisputed fact, that any federal employment and all that stuff is basically entrapment. It is entrapment. If the only people that's supposed to be paying taxes are public officials. It says it in Title 26 United States Code, which is the Internal Revenue Code, and the Treasury Regulation, which is the Code of Federal Regulations. Now, this United States citizenship thing, and this is where they're not making people understand that, yeah, you're supposed to be saying you're a non-citizen national or non-citizen able to work. But people think that makes them an immigrant, but they don't understand the difference between the United States of America, the 10 square mile radius, 28 USC 3002, 14 and 15, and what you would consider to be America, the North American continent, which is the Republic of America. Constitutional bound. I come in there and I say, okay, if I'm coming there working for the government, I'm coming in working for the government, and the government is the state, city, municipalities, and the federal. If I'm coming in working there, then I need this. This applies. This absolutely applies. Now, when we go over here to what a non-immigrant is, common non-immigrant visa categories include B, F, H, J. So if I'm in some Cal state, just sticking with California, in a Cal State University, not a UC, a University California, just might be, usually those are not falling up under, those are considered to be private schools because they only get their funding from private donors unless they get state funding and they're within the Department of Education. But under the circumstances, you're coming in as a temporary worker, exchange visitor. I don't know what exchange visitor means, but temporary worker. Well, you're temporary in the meantime because you only work 8 hours a day. So if
You
work
gotta
8 hours,
remember, this is the U.S. It's not.
I know.
Okay.
I know. But if I work 8 hours a day, I'm only working 8 hours.
So you know
I'm
this
not
act.
working 4 hours.
This act. You know the Real ID Act falls up under this also.
Mm-hmm.
All of that.
Okay. I ain't even looked into it because I don't want no parts of it.
And if you read, it tells you so intently that you need to register with a database of biotech by way of fingerprint at 14.
Okay.
Or you're violating this U.S. code.
Okay. But there we go. We know U.S. codes and statutes are for public officials only. Anybody that's working within the United States, city, any federally funded department, agency, otherwise. You know what I'm saying? Yeah, you are a United States. You are there. You are there. And yeah, you should get a visa. This is good information. You are considered to be a non-immigrant visa. Yeah, I like that. Shit, I come in there, boom. So if I go get a job, all I gotta do is drop my birth certificate. I got my birth certificate. Here you go, blink. There's your information. That's all you need. It's authenticated. Take that information. You're good. But I'm not a United States citizen.
No, not Not if you after you turn 14. The birth certificate is good, but you don't have to go through so much registration now. You just have to go and get a driver's license or a ID card or a student ID card, or you understand? This is the
Right.
registration from that point forward once you have a birth certificate because you're already pre-registered.
Okay. Okay.
Or it will be considered a re-registration.
Okay. Yeah, that's good information though. See, I know how to flip that shit upside down. You know, at the end of the day, if you know how to apply it properly, then yeah, it can work. It could definitely work, and it's pretty much good. You know, I know you move around a little bit, so that temporary thing is one thing that you can provide. Let them know what's happening.
Get
Yeah,
your
I'm definitely.
diplomatic passport. Go ahead and apply. Go ahead and send a notification to the passport consulate and tell them, give them a affidavit. Send an affidavit with it being notarized on your identity, and there in turn send you a document showing that you're indigenous or whatever you claim to be. And now from that point, you go down and get your passport off of that representation.
Right.
When they get that information back, it's gonna be turned. It's gonna be turned around, and they implement. It depends on how you fill out the application or not, but you can end up getting a diplomatic passport, a passport with a diplomatic immunity.
Yeah. Yeah, did that. Yeah, did
These
that.
processes are not hard at the
No, they're not. They're not. They're not really. They're
They're
not.
just knowledgeable. You just got to be knowledgeable.
Yeah, exactly. I mean, really, more importantly, you just got to get comfortable being in that space. You know what I'm saying? It's like foreign shit. It's like rocket science. You're like, oh man, make you feel a certain type of way. Like shit, I'll figure this shit out. But once you get into that comfort zone, then yeah, it's definitely doable. Definitely doable. Now I'm gonna do mine all over again. I'm gonna give it some time. I want shit to rest, and I want everything to rest. Because I've been on. I want things to rest.
This is why I'm so adamant on someone creating their trust as in a foreign trust, because it shows that much more identity that you're not part of the U.S. You're foreign to the U.S. You're an alien to the U.S.
Right. Yeah.
And you can handle your
Every
business and
non-resident
keep all your
aliens.
assets.
Non-resident aliens.
Correct.
That's the status.
Yeah. Go ahead. I'm gonna go get. I'll be right back. I'm gonna get some water. I'm listening.
Yeah, that's the status. Or go under that Title 8, 1101, 22B. Pull that up right quick. That Title 8, 1101, that's a cold piece, bro.
All immigration court.
Through. Huh?
I said there's only immigration court. That's it.
Yeah. You can hit their ass with strictly articles. The articles of the federal, the service articles.
Oh, okay.
All right. So this deed of trust. Okay. So Nadi and Jada, you guys are very you guys have trust set up. You guys have done your thing, and let's apply it to this mortgage. Let's do this. Let's apply it to this mortgage. I don't want to make it seem like I'm talking to myself. Let's apply this mortgage situation. If everything works in the form and fashion as it has been laid out, You know what I'm saying? What is okay? So, what is the approach to the remedy? Because that means there's a lot of money on the table. Like I showed, if it's $300,000, I saw 5 ways they use your information that you had to fill out to get what you needed to get in terms of that $300,000 house. See what I'm saying? So we got about $1.5 million worth of the credit that been issued in the form of a letter and in the form of an application. Then on top of that, we ain't got to the part where the sister got into hypothecation. We ain't got to that part yet. But let's just talk about the consideration, the promise, and all this type of stuff. And that it is a deed of trust that was set up. Trustor, trustee, beneficiary. So let's just say as a third-party donee, right? So we got donee, we got what was it called? It was called a donee beneficiary, right? So we got a donee beneficiary by Black's Law, which is in a third-party contract. Because it's a third-party contract. You got multiple people that's in there, and you don't know that the underwriter is present. So you got a third-party contract. How, being that it's been over 3 years, you got the tax rules on 36 months, it's over 3 years, and it's over 5 years. How is it possible to be able, based on the fact that you have now came into the knowing of this thing, so, you know, statute of limitation might not be up because you didn't know. How would you be able to, what would be a good way of approaching this in order to get recoupment, and not just recoupment, restoration of your land and your property?
Well, there's one problem. The deed of trust is still circulating. You got to remember the deed of trust is used basically as a collateral for
Right.
real estate.
That wouldn't be a problem for me though. That's not a problem.
No.
That's a great thing, ain't it?
No, the third party, which would be the donee beneficiary, gets a loan on that. They get several loans on that, which keep it active. It's keeping that deed of trust in a process of current. It's not just being idle. So your name is still transferring from one loan to another loan to another loan off of that deed of trust. So that's one of the reasons why they still uphold their not repo, but debt or repossession of the possession of the real estate.
Okay, you got that. Now, what I'm going to do, let me bring this down. I'm going to bring up this other thing.
See, these contracts that we're signing are really, and applications are really deeds and bonds, and we just giving authority. But once they get a hold of that signature and that SS number, they can continue using it and operating it as the fiduciary for that specific account. That specific account never dies. It's always in use. So by us not attaching an allonge with these contracts, with a staple and attaching it, we're losing our respectfully right to uphold or to observe or to reserve it.
Right. All right, so what I got up here, this is corporate juris secundum. These are some notes. Right, you got CJS 90 that deals with trust. That's volume. I don't know if that's volume 90 or whatever, but this deal with trust, section 162, intention of creator or settlor. Now we looked up settlor from Black's Law. Right, we got settlor right here. Still had that up, so we got the settlor right here. Right, so it's one who creates a trust. Also, the grantor or donor in the deed of settlement. We got that. Also one who creates a trust. Now let's go over here to settlement real quick. Okay, in contracts. Let's see what's going on. Settlement. Okay, so let's say in contracts. We got contracts and conveyancing. Adjustment or liquidation of mutual accounts. The act by which parties who have been dealing together arrange their accounts and strike a balance. What is that? 1615. Okay. Settlement. 1615. Also, full and final payment or discharge of an account. Not it. Straight up.
Hold up.
No, hold up. Let me do the conveyance.
Look up settlement under financial law or bankruptcy law.
It's only giving me what I could get right here. Let's deal with conveyancing. Contract law.
You in black law.
I'm in Black's law. Hold on.
Yeah. That's not gonna deal with bankruptcy or real estate.
All right. Conveyancing. That deals with real estate. A disposition of property by deed, usually through the medium of a trustee. And that's what I was talking about. Fidelity. The trustee that's in the deed of trust that issued the title insurance and opened up escrow.
What I'm trying to say is judicial function is not gonna go off of the black law letter. They're gonna go off of bankruptcy law or financial law. We're dealing in real estate. They're not gonna use these terminologies in black law.
What about probate practice? Is that good?
Bankruptcy. Probate is bankruptcy.
We don't have bankruptcy, and we don't have bankruptcy. All right, so we're gonna deal with this on the face. Let's deal with this on the face, right? But what it says right here in contracts, because they are operating on the Uniform Commercial Code, are they not? Are these things governed by the Uniform Commercial Code?
Yes, but it's not the United States doing it, bro. It's individual companies. So you're gonna have to go up under what they're regulated under is bankruptcy law. They're not gonna be regulated up under black law, bro. Okay. You're not dealing with the United States. You're dealing with the other extremities.
Okay, I get that. But let me add this. If you're using a social security number that is under the Social Security Administration, which is under the United States government, you are using government entity, you are using government issued things. I can't think of the word I want to use right now in that situation, but you are using that. And the date of birth that is derived from the birth certificate is a government issue instrument. There you go.
It is, but you're signing contracts and giving other individuals active fiduciary over that account that has been created. They're not governed under the black law, bro.
But look, that's where
banks and things are not governed under the black law. They don't fall up under that.
That's okay. So in this situation, see, creative. Got to be creative with this. We don't know. We're assuming what they're doing. We don't know what they're doing because they never tell us. They never.
I'm telling you now. I'm telling you now.
Yeah, I know you telling me, but look, at the end of the day, I take it with a grain of salt. I take it for what it is. You
now,
on the
what's gonna supersede this in itself is gonna be trust law. Trust law. If you use trust law now you got all of them in a grasp. That supersede all of these instructions. But when you're dealing with certain companies or certain branches of the government or even the government itself, it's going to be defined under a certain definition, different definitions. Not all companies is going to be structured up under the black law definition. Even when you go to a judicial litigation, they're going to judge off of what that structure is up under, bankruptcy, financial law. You check what I'm saying? So this is what we need to be doing study when you're looking about real estate under bankruptcy laws. Real estate it falls different.
All right. So look, that all right. But I think you making my point though. You are making my point. What that's okay. We can agree with that, but you're saying that they can't. But what moves that to the side is the fact that they have an EIN number. Number one, they have an EIN number. They have a CP 575. They have that. They are registered in states, right? They have their things registered. They might be private in a sense. They might be registered in some tax exemptions, areas or whatever, but they still are registered to do business here. And in order for them to do business here, they are registered with SAM. They are, they are registered with SAM to get these big contracts, to get funding, government contracts. On top of that, they're creating real estate investment trusts, which have an EIN number that is registered with the Security Exchange Commission. So they are, and they have. HJR 1933 with the New Deal made the government liable for all debts, public and private. So that means you can't do any private with these entities. Can't. It's impossible. We could do it within each other, but with them, they have, in order for them to do business in the public, they have to be registered because everything is free. Everything is already prepaid. So they have a duty and obligation, but the flip of the script is how they're able to get in the position of power. That's why I said that deed of trust is not just falling under the Uniform Commercial Code, not just falling under trust law, not just falling under consumer law, but it's also falling under the tax code. Everything is falling up under those things, man. They up under everything. And there's a security agreement and a hold harmless indemnity agreement language in there. It's covered all angles. But that's payment. That's payment. Now, we want to say, like in conveyancing is a term that we use, right? But down here, so we got what settlement is. So strict settlement, voluntary settlement. So we don't have that right there. So this settlor, this is what we have. One who furnishes the consideration for the creation of a trust. So if consideration is considered to be something of value, and we know it's something of value, then that means they took that. And they knew that we gave them that consideration, what they issued to us. For us to endorse that, fill it out, put the information in, provide it to them for they can receive the consideration in order to go to the Fed window, go get that money. They go get that money, bring it back over, cut us a check, so that way we can go get the thing to live for own personal and family usage, not for gain, not for profit.
Well, if you look into complaint against a big actions, you have to address the Consumer Financial Protection Bureau, which will be the CFPB, prior to putting in a litigation or a letter to intent, right? Or any violations that they might cause.
Yeah, you break it up now, Nutty. I don't know if you move locations, but you copy now. Yeah, you still choppy.
Yeah, I can't.
Yeah, if you can hear me good, We can't hear you good. That means just your location, or it's just something. Yeah. But let me say this real quick now. Under the circle, let me go back over here. This right, I want to come back over here to corpus juris secundum in these notes, right? The intent of the creator or settlor. We got a clear idea of what we have going on in front of us, right? Violation of intent, substitution of discretion. And I think Chief I.M. mentioned that about these courts and judges using their discretion and these police officers using their discretion. This is what we have going on here. But I use it all the time. You can't use your discretion to violate equal protection of the law. You use your discretion to make sure that those things are protected, not violated. But anyway, neither court nor beneficiary, not legislature, is competent to violate settlor's intent and substitute its discretion for that of the settlor. The intent or intention of the settlor of the trust is the law of the trust. So, but this is the issue with the mortgage, then I'll let y'all get it back. So this whole deed of trust situation is already pre-drafted by them. In the intent of anything that they have in there, the trustor is the one that's giving consideration. And that is me. Just take it to me. I'm the one giving consideration. So all of these things are supposed to be for my benefit.
Yeah. Peace, Aton. Peace. Who we got on? Nadi. Who's that? Peace of the family, man. How y'all doing tonight?
What's going on, bro? Go ahead. Y'all got it. Go ahead.
Man, great conversation, man. I guess.
Yeah, but you late as always, though.
You said what?
You late as always, though.
I mean, you know, I be jugging, man. I be moving and grooving, man, all day, man. From the time the sun go up and go down. But
all right. So let's deal with what's in front of us.
Yeah. You're going into the law of the trust, right? Which is the trust indenture, right? And a settlor is no different than a creator or a grantor. They all hold the same. They hold the same titles, and their word is law. That's the trust indenture, right? And they create the trust indenture, which are the responsibilities which are delegated to the trustee for the benefit of the beneficiaries. You know what I mean? So 100%, only thing that I would say is that I don't believe that we're party to the trust. I know that we believe that we finance it through the signature and they're going into our private account and pulling out public funds to finance the transaction. All these things are very well true, but I don't believe that makes you party to the trust. I don't think trust
definitely makes you party to the trust.
I don't believe that you're party to that trust. That's where, and this is spelled out in case law. This is spelled out in maxims of law. Equity does not support a fraud. You know what I mean? Like, that's a maxim of law. Look, maxims of equity, right? So, yeah, man, you're right about all these things, but you didn't settle. You're not the settlor. You didn't create that trust, which that mortgage is under. You didn't create that trust. You didn't write up the paperwork. That trust was issued by the bar guild. You know what I mean? It's an ordinary.
You're talking about the deed of trust. Okay.
Any document that's issued by one of their intermediaries, which are banks. Banks are not even banks, they're called intermediaries. They just go in between you and the treasury. That's what they do. They can't extend credit and they can't loan money because they have neither. So they're just an intermediary. Look up the word, what I'm saying. So what I'm saying is these are all public transactions, and I don't think that we are actual parties to these transactions as we think we are. Maybe in a different capacity we might be, but I don't, as a settler, no, you're not a trustee. You're not even a beneficiary. You're a fucking renter. You got a mortgage, you're paying rent, my nigga.
But you're the grantor. But you're the grantor.
No, I think that's what we believe. No, what is a grantor? Look up what grantor is. Grantor, settler, creator.
Yeah, you way behind us, Chief. I am. Like I said, let's move forward, brother. No. I already went through it. Let's go forward. Move forward, brother.
What I'm saying is that those words are all synonymous terms.
We already know.
Creator, executor. These are all synonymous terms. These are the ones who put the ink to the paper for their will to be manifested in reality. The bylaws are the trust indenture. The trust indenture is the body. It tells you, it's like the Constitution. You know what I mean? Like the trust indenture is like the Constitution. It's the body of the framework. So you must stick to the body and to the terms and conditions that are written within the body, which is the trust indenture, for the benefit of beneficiaries. And we're not none of that shit. We're just renters. We're under fucking what's the old English law?
Well, how are you nothing if you brought the consideration to the table? How are you nothing?
Consideration? Did you bring a signature?
And you brought a down payment.
I mean, you can argue that. You
put a deposit down. You put a deposit down on the property. I mean, you the only one that brought real energy.
You know what? Even better as a consumer. Yes, you have consumer protection, but you're not the settler. You're not the creator. You're not the grantor. You're not the executor.
That's not true. That's not true.
No, if you create your own shit, you are those things. But under their shit, you're not any of those.
No, that's not true.
You're not even a party under Rule 12 of the Federal Rules of Civil Procedure.
That's not true.
Dismiss every claim that you bring in federal court for failure to state a claim upon which relief can be granted.
That's not true.
All right. Well,
yeah, they could do that. But if you look at Iqbal and all that stuff and all them case laws, them putting a 12B6 and doing any type of 12B6 motion is admitting guilt. All they're doing is looking for help from the courts to assist them and say, oh, well, we need to change jurisdictions on them and we're going to utilize these all caps.
Man, Rule 12B.
And then move it to NREM. And they do that on their own. They do that on their own motions. And if you have somebody that an attorney brings in any type of response with a declaration behind it, that is not considered to be valid, and that should be ruled in the plaintiff's or the claimant's favor sua sponte on their own motion.
Yeah, but what you got to remember is that what you're dealing with, you're not dealing with common law equitable courts. You're dealing with commercial courts.
But that's not supposed to be what it is.
But it is what it is.
But that's why I said earlier, hey, as soon as an attorney responds in any type of motion to dismiss for failure to state a claim where relief can be granted, that is declared, that has a declaration by an attorney, and that judge in that court does not dismiss that or do a sua sponte ruling without oral argument in my favor, that judge is getting recused. You're out of here. And I'm gonna tell you why.
And then you're what? You're removing it to the higher court. You're going straight to the Supreme. Have you been to the Supreme yet?
Yeah, I have.
Ooh.
Yeah, but what I'm saying is that let's stick with this though, right? Let's stick with this. This is what I'm saying about what I said in California, we call it peremptory challenges, right? For cause. You get rid of any judge. If you had no hearing or nothing, no physical proceedings, you could remove a judge for cause because because you just have a bad feeling about it.
Hey, OG, check it out. I got a disqualification of judge document. I've used that shit directly and indirectly 14 times, and that motherfucker is golden. We could pull it up one day if you want to. It's in my, we could pull it up. It's golden. You drop that bitch into the case, the judge is automatically removing himself, and you can rinse and repeat. You know, just depends. You know, it's mental fortitude with this shit. None of this shit is real. It's just mental fortitude. How far are you willing to go? How far are you willing to fight? And it's all paperwork and knowledge. You know what I mean? But it's not for the weak. It's not for the meek. Even though the meek shall inherit the earth.
Right.
It's not right now. The wolves are running it right now. The vampires, they're running this shit using words of art, magic, grimoires and shit.
Yeah. All right, so look up what an endorser is, bro. And
Man, why y'all keep making me go back, man? I've been going through endorsing.
Okay, well, you don't have to go. You don't have to go back.
Yeah, you gotta.
Listen, an endorser has a secondary liability. So if an endorser that's on a contract, a check, or whatever he signs, he's actually turning over the rights of whatever he's signing over to who he's signing it over to. It's not, you're not the
Unless it's
grantor.
special deposit, right? Unless it's on special deposit.
Well, yeah, unless it's special deposit.
Nah. Special deposit is
banking.
Document deposited into the private side of the fucking court. The court is a bank. The court has a positive and a negative ledger. A special deposit is deposited into the private side to fund the public.
Right. Correct.
That's going into equity.
So then that wouldn't allow them to do what they were doing. That's why you would do that. Instead of a general deposit.
You know what you're doing, but what I'm saying is, you know, every judge wears two hats. They wear the at-law hat, and they wear the court of equity, exchequer. You know what I mean? They operate. They have an equitable hat and an at-law hat, and depending on how you come to court, it's fine. If you titles, they'll go into equity, but you got to know how to merge the title, the legal equitable title. You know, like I'm saying, this is like high level magic that they're using. This isn't like for the meat. You know what I mean?
I don't think it's high level magic. The magic is missing from it. There ain't no magic. That's the problem.
And go to court tomorrow. And
that ain't magic.
No case.
That ain't no magic.
Man, nigga,
they're making you can't bring none of your magic there.
Gets up, magic.
Shit, they ain't doing no magic. That's just if you believe in what they're doing.
No, what I'm telling nigga, could you
the magi, not them.
Could you have created the system?
They need your energy to create anything.
Every city throughout America, every county in America, every town.
Yeah, they have replaced your magic.
Unison.
And stripped you down, so you come in there with a what is it? A public defender. That's crazy.
Shit, nigga, you already
took an oath not to use no magic.
As soon as you,
or at least make sure you couldn't use yours.
They convinced you to sign your rights over to somebody you don't even know.
Yeah,
that's magic, nigga.
They gave up all your magic. Shit.
These niggas.
Imagine what they did. What they did was put you in between a rock and a hard place, and that wasn't magic. They put that lead on you.
Man, listen, I'm telling you, bro, if you go to court tomorrow and you sit in there the whole day, I don't know if you got to work tomorrow or not. If you don't, I would suggest it for everybody listening. Go in there and just watch how it goes down. There's no question. There's no kickback. There's niggas is just falling in line like sheep to the
Yeah,
slaughter.
they're not saying nothing. They're just following orders.
Man, it's high level wizardry, man. Like I told the story, I think maybe last month on Aton channel about when the mother of my child, when she slipped coming out of our crib, and I sued the complex, and I completed the private administrative process. So I served them 3 times, VA certified mail, and then upon counsel, one of my OGs told me, if you don't know what to do going forward, the best thing for you to do is hand it over to a law firm, and instead of them taking the 40%, which they normally take, they're only gonna take like 10. They sent out, I contacted the local, not local, but the big dog in my area. They came out, they sent a guy out. This nigga was weird as fuck. This nigga he read my paperwork, he was so excited, he was like jittering. He was like, I love words. He was like, words are power, woo, 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 woo. And I'm like, he was like, your grammar is correct, but your grimoire is even better. I'm like, what the fuck is the grimoire? Nigga, I had to look that shit up. Grammar, grimoire, and glamour are all the same word. They're interchangeable. And a grimoire is a book of spells. Grammar is a book of spells, and glamour is spells. Glamour, makeup, the vanity shit, it's all fake. So this nigga told me more than nobody else could ever teach me. It was crazy. And I'm telling you, these motherfuckers is using spells on us, bro.
Man, but we learned to spell in grammar school.
Yes. There you go.
So that's normal.
Yeah. You learn to spell in grammar school. Grammar, glamour, and grimoire are all the same word. 1789 etymological dictionary of the English language tells you that. Shout out Yafa Bay. The sister's a genius. She's a word breakdowner. She's not a wordsmith. She doesn't create words. She breaks them down. She's a goddess on that level. A true steward. Yeah, man, they're using spells. I'm telling you, like, listen to Aton for a week talk and then go down to the courthouse. You hear me, Aton?
Yep, I hear you.
Yeah. Listen to him. Listen to his these classes he's giving out. You know what I mean? With your shows. Listen to him and then go down to the courthouse and see how they're all on the same team. They're all officers of the court. The clerk, the bailiff, the judge, the attorney.
Man.
They're all officers of the court. They all are. They're doing the court's business. Who's the court? It's the queen, right? Or the king, depending on who you believe is still alive or ain't alive. You know what I mean? Yeah.
Hey, let me ask you a question then. So you mentioned grantor, settlor, creator, donor, all the ors are pretty much one and the same.
Yes, depending on the framework of how you mold the document.
So
right?
if you come into knowing,
selective language.
So if you come into knowing, right, we're dealing with a deed of trust. A deed of trust, as I looked up, deed of trust and promissory note are simultaneous, synonymous, I should say. Not simultaneous, but are synonymous. So if we know that it's given consideration and we transfer, right? It was done maybe 5 times. You got $1.5 million on a $300 loan that they supposed to be issuing you. So you got $300 on a credit application. You got $300 on a loan application. You got $300 on an escrow, title insurance policy. You got $300,000 on a deed of trust. That's what 1.2, and I think there's another investment on the $300,000 times 10. But we ain't worried about the times 10. Let's deal with the face value. And you come into the knowing. It's after 5 years. Let's say it's after 5 years. You come into the knowing. Is there some way of recouping or repairing or restoring of funds and property and or real property and land? You got it.
So coming into knowing what type of contract are we talking about?
We talking about mortgage.
A mortgage contract. Okay.
Not without reporting it.
I would say under the contract, you don't really have. I mean, if you were going to sue them for like stealing your signature, maybe that, because you know they got to duplicate that shit. And, you know they got to endorse that shit on many documents for this entire transaction to go through without your permission. But maybe you did give them permission. Maybe you signed over a limited power of attorney and you didn't know that you did. You know, because maybe that's in the mortgage contract. People are not aware of that. I don't know, depending on the individual's mortgage. I don't know who your lender was. You know what I mean? So there's a lot of, but I would say, yeah, as far as like you being robbed out of money, shit, you gave none. Because money, according to the Constitution, is gold, silver, and precious metals. So you didn't give any money. Now you say consideration. Consideration under contract law is coming to the table with the same or the equivalent of the same. So you gave me your signature. Your signature is worth $1 billion, and I give you $1 billion in rights. You know what I mean? Just to make it simple. So I don't believe, you know, I would say that contract law is the way that you would go, right? Because you got the 4 doors of the contract that you can utilize at any time. You can reject, you can accept, or you can conditionally accept, and absolute acceptance. So those are the 4 doors of every contract. So you can, I would say your best bet is playing the contract game, right? So conditionally accept the terms and conditions upon the contract, upon proof of claim that it's a lawful contract, not legal. You know, that's the type of game I would play with that. As far as like doing the motherfucker because they didn't get $3 million out of my treasury account. Hell no.
All right, so let me take it in. You know, usually their response when you anytime you dealt with a mortgage situation before, what they're going to do is they're going to send you a copy of the deed of trust. They're going to send a copy. They're going to send accounting of the payments that you made to that company. That's what they're going to provide. They might say in the letter, this company is the servicer of the account, and you know there was a loan that was given. The lender was this, and there was a loan.
Sending them a QWR, qualified written request.
This is after the QWR.
Okay, all right. I just want to follow you. Go ahead.
Yeah, so they're gonna provide you a deed of trust and copy, and it's gonna probably be redacted. Then they're gonna probably give you list of statements, you know, payments that you made over the last 7 years. Let's just use the number 7. So What is your response to that after your QWR?
Well, so I did that, years back, man. Family member of mine, they ran into a tough time, and they were starting the foreclosure process. They got 90 days behind, and they foreclosed on like the 6 month, and they were nervous. And I came in, I did a QWR, then I followed it up with the private administrative process. Once they defaulted on the actual questionnaire that I sent them, I followed up with the notice of fault, notice of default, notice of fault, opportunity to cure, notice of intention to sue, notice of default, going to sue type language, the third level.
Right.
And then from there, I did a cease and desist. And believe it or not, man, that shit worked for like 5 years.
And they came back, huh?
They came back, yeah. Ultimately, they sold the debt. The mortgage company went out of business. That's normal. These mortgage companies go out of business all the time. They sold the debt to another company who came after the debt, and I was far removed from the situation at that time, but they had the house free. Basically free. They had the house for 5 years and wasn't paying no payments because once you go on the default on a mortgage, they stop collecting payments. You know what I mean? They're not even going to take your payment. Even they're going to tell you to deal with the attorney. That's what they tell you to do. And this is the same thing in an eviction. You know what I mean? So, yeah, ultimately, they ended up selling it and to someone else. And then I found out maybe a year later after the woman who I was helping, family member, she ended up selling it on a quick title?
Quick claim?
I want
Or
to say
you talking about the short sale?
Short sale. That's it. I say quick title, but I meant short sale. You're right.
Yeah.
So she ended up doing that, and she made a few dollars. So the property was worth $500,000, easy. But they convinced her that she owed $230,000, and I was telling her there's no money. And this is what we fight. We fight our people who don't know. You know what I mean? Like, there's only money of exchange and money of account, and neither one of those is what we're talking about. So it's like that's our battle, as those who have the light. You know what I mean? That's our battle. We got to deal with that type of shit, man. Trying to educate your client while trying to help them. You know what I mean?
Yeah, I mean that's that is the tough part, because people ain't there, you there, and you got to find the middle ground in order to not feel like you trying to run them over and pressure them, and they not understanding that it is a tough thing. So I feel you on that, But 5 years, you look at timeline, right? Timeline. Nothing was ever recouped from that, right? So the other aspect of what you didn't do was notify the other agencies. That is, you have control of the currency.
Facts.
You have depending on what type of bank it's FDIC or it's NCUA if it's a credit union. You also have the Treasury and so the Revenue Service where you can do a clear audit. You can do an audit that way. You can get that thing audited that way. And if you know somebody, right, that does securitization and mortgage, securitization and mortgage audits, you get a clear idea of what you got going on in this.
So let me say this, Aton, to my credit. Let me say this. I didn't know all this is 15 years ago.
No, I'm saying moving forward.
15. So I remember this was the year she was born. This was like one of my first in-house clients. When I say in-house, I mean like family. You know what I mean? And they wasn't paying me shit. They just needed my help. And I just had a little light. I didn't know to identify the proper agencies, you know what I mean, to make the system work against these motherfuckers. I didn't know that. You know what I'm saying? I wasn't hip to that at that point. Cause you know what I mean, I've been in the truth a little bit longer than I've been dealing with the law. But the truth brought me to the law. You know what I mean? Cause the word law is like within the Bible is like it's used more times than like any other word. So it's a law book before it's anything else. So yeah, but it just sharpened me, man. You right. You know, you got to utilize your public servants. That's what you're talking about. Going to the IRS, to the Treasury, to the controlling administrative agencies that might govern the policies of this loan or this fake loan or whatever it is, you know, yeah. And it could have probably went to 10 years. You know what I mean? She could have been in that. She could have been in there for 10 years instead of 5. She was thankful. She stacked up. She stacked up like 300,000 in those 5 years. You know what I'm saying? You know, all she was. It's crazy, but you know what's even nuts? How interconnected it is, how woven it is, right? Because once you stop paying your mortgage, it's like the people that know you're not paying your mortgage, they contact the electric people. They contact, you know, the shit you need to make your house functionable, the water company, shit like that. It's like they contact them and let them know, like, yeah, these people are not playing by the game that we designed. So I need you to put a little pressure on that electric.
No,
you know, you might be paying your electric, you might be paying your water.
It doesn't matter because it's dealing with liens, right? Encumbrances, real estate investment transactions. What they're trying to do is get assignees to get on board. And if they can do that, especially, you know, because that stuff starts with, once you see a notice of default and all the assignments, whatever, and the county recorder is recording these instruments, everybody gets that information. Everybody gets that information.
Yeah, it's public information. Hey, you know what's crazy? And it wasn't until I started researching the law and shit like that, and I brought this shit to my brothers. You know, I got 4 brothers. We all a year apart. And I was like, bro, you don't think that shit's odd that every time one of us catch a case, this is years back. I'm like, that attorneys start calling us? Cause they you know what I mean? Like we don't, like the public record is, we are oblivious to it, that it even exists. The county recorder is in every civilized country, state, nation state, city, town in the world. In the world, you can get mail anywhere. There's a county everywhere. It could be under the Sharia law, it's a county. It could be under the Hindu law, it's a county. Everywhere in the world, bro. You know what I mean? And we are oblivious to it as in North America. We're oblivious to it.
Right. So I don't know if you answered my question though. Is there a remedy in that? Is there any reparations or restoration of monies and property and land based on you coming into the knowing, right? To take your people for an example. Once you learn about these things, and we're talking about trust law now, we're talking not just trust law, we're talking about the definitions, grantor, settlor, what I just provided, corporate juris secundum, And let's bring it back up. The intent. What's the intent? What was the actual intent of the settlor or the trustor? What was that intent? Right? We had endorsed, but I guess he couldn't. He didn't have. He couldn't. Wasn't working. But if we see right here, right? So we got merger of estates. We got rights of construction estates. It's a rule of equity that once a trust is created, it is thereafter to be treated as a trust. So if it's treated as a trust, and we have all these other issues going on, and let's say we dealing with endorsement, we got consideration, we got the grantor, settlor, donor, trustor, bailor, all these different aspects of what we thought it was, and we know a deed of trust is also a promissory note. And now you learn all this. And you're the owner of the land. You find out that you have an estate or interest in the land in fee simple. And it states that. And it's insured. Is there any reparations and restoration in that? And I don't need you to give me a through Z, yes or no, and why? We still here? Well, it's 6 o'clock. What are we on? 4.5? We on 4.5 hours. I think we pretty much reached our limit anyway.
Hey man, listen, I heard you, man. My bad, bro. I had to run to the bathroom, bro. Listen.
All right, we're about to close out. This will be the last one. We're about to close out.
No doubt, no doubt. So this is the whole thing, man. So is there any restitution and coming into the know and then realizing that you're being taken advantage of in the public? No, bro, because it's the public. No, you're not the grantor, you're not the elector, you're not the creator, you're not the trustor, you're not the executor of any of these contracts. You're not a party to them. You're the public, and the public is only thing that's in the public are citizens. You know what I mean? So that if you're going to play the public versus private game, your rights are in the private sector. Your rights ain't in the public. Now, can you bring someone on a public claim who's in the public? Yes. So you talking about suing someone who's doing business in the public? Yes, you can do that. But your rights are not in the public. Your rights are in the private contracting. And you haven't set up no private contracts, bro. You signed a public contract. That shit had an OMB number on it if it was a mortgage application. The Office of Budget and Management, the contract is financed by the Treasury. No.
Okay. All right, let me ask you another question then.
Say one question, cuz. Come on, cuz. I'm fucking with you. Go ahead. I'm fucking with you.
Let me ask you another question. I ain't studying you. I got another question. Now, the bank, do they have an EIN number? That could be found in the public sector. That's a yes or no question. Come on, we got to go quick.
Yes.
All right. Do they have licensing?
Yes.
Registered with the government agency?
Yes.
Do they get funding, or do they have contracts set up through SAM and other state avenues to get funding?
Yes.
Okay.
It makes them public.
All right.
If
cool. You answered my question. No more questions, cuz.
All right, Lord, I'm out, man. You have a good night, brother.
All right, my brother. Take care. All right, shalom out. J-Dub. J-Dub, you there? Yeah, he probably just chilling. Hey, look, gonna let y'all down. Hey, man, this was a good one. Appreciate y'all coming up here. Chief I Am, J-Dub, Heartfelt Centers, Nadi. Appreciate y'all coming up here. Everybody, none of your business. Appreciate everything. And yeah, Jamula, Nadi, endorsing. I put that up there. You didn't have everything. Derek was here. Original RCJ 22. I keep forgetting who that is. We had a new somebody come up here, the Detmore 7. Hopefully he comes back. King Chameleon, Big Dog Philly OG, Richie Rich, Reclassified. Hey, and everybody else that was listening that didn't put in, yep, Copper Draco. Hey, look, what we gonna do is we gonna get up out of here. We are going to get up out of here. But before we do that, let's finish off the young lady. We can't do her bad justice. Let's let her finish.
You're going to then go to a section and you're going to see this thing called RESPA. One of my favorite parts. RESPA. If there is a surplus of funds held in an escrow as defined under RESPA, the lender shall. Did it say the lender might? Huh? It said shall. All right, shall. The lender shall account to borrower for the excess funds in accordance with RESPA. So that means if there's extra money laying around that they made on you, which we know they did because I taught you guys already on my previous videos that they hypothecate your loans. We're not there yet. I'm trying to help y'all just learn the vocabulary, all right? So that tells me if there's money left, okay. So if the borrower is always the...
All right. So we go to hypothecate, right? If we go to hypothecate, that is 952. Page 952, hypothecate. Hypothecate. We got hypothec is used to signify the landlord's rights, which independently of any stipulation he has over the crop and stocking of his tenant. It gives a security to the landlord over the crop of each year for the rent of that year and over the cattle. Hypotheca was a term of the Roman law denoted a pledge or mortgage. As distinguished from the term pignus, in the same law, it denoted a mortgage, whether of lands or of goods, in which the subject and pledge remained in the possession of the mortgagor or debtor. And we're going to pick up from there on the next one. Let's go down over here to hypothecaria, hypothecate. To pledge a thing without delivering the possession of it to the pledgee, the master. When abroad in the absence of owner, may hypothecate the ship, freight, and cargo to raise money requisite for the completion of the voyage. Whew, that's deep. The term borrowed, hypothecation, the term borrowed from the civil law, insofar as it is naturalized in English and American law, it means a contract of mortgage or pledge in which the subject matter is not delivered into the possession of the pledgee or pawnee. Another word. Or conversely, a conventional right existing in one person over specific property of another, which consists in the power to cause a sale of the same. Ain't that something?
though it be not in his possession, in order that a specific claim of the creditor may be satisfied out of the proceeds. Now, we're going to come back to that, but we have new terms here. Pledgee, pawnee. All right. I think we have those. Let's see. The master went abroad. Oof. All right. We're going to stay right there. But now, hey, great thing right here. This is what we're going to do. When we out of here, we out of here. This song is going to mean to what? Damn. So taking up interest in something. Can you give some suggested reading? Not really. But I'll think about it. And I will email you. None of your business. All right? I'll think about it. Might have some stuff for you. But under the circumstances, this is what we're going to do. We're going to play this. And we are. When the song is over, it's over. All right, here we go.
I'm the coach, quotes coded in oak with a ghost loaded focus. Chrome in the coat, king with the cloak, smoking that hocus pocus. Infinite styles, pivot and pile up the mileage. I'm wild with the science. You see the line on my avatar, iron jaw pride. I to devour the silence. Why you niggas steady lying? Got me laughing hard, satire and fraud. I fire the sword. Wise get crossed when I'm sparring with all the guards. Author of art, carving a mark in the bark of the market at large. Target the sharks, heart of a Spartan. I sharpen the margin with bars. You rather bargain and dodge. I'd rather you come get your taxes done. Black suit back, room facts in a stack. I'm relaxing the maximum. Get out of the pocket, the profit of rocket. Then I just might tax you punks. Bracket your funds, I'm stacking in chunks. Reacting to acid, you're begging a punch. Sometimes my community hard-headed, scarred, dreading the lessons. I chart head and start spreading the message, embedded in pressure. Sovereign living, I'm private with it. No corporate percentage. Discharging debt with a pen stroke. You still don't notice the vision. I've been telling y'all you don't want to debate me. Weighty and ready. Great with machetes, linguistically shredding the petty. Grab these 15 acres. Landscape major, plan made paper. Land patent stamped and sacred since my campaign greater. I ain't talking about Ice-T when I say that I can show you law and order. Court recorder, I sort the torture, contort the border. I eat the case, beat the state, leave a trace in a raw supporter. Briefcase aura, got your baby mama thinking that I'm a lawyer. Seminole Indian sentiment, militant on Samba and Sawyer. Private enrollment, tribal component. I'm the boss if you trying to employ her.